applicant, my lord, recommends item number 29.
29.
29. I have taken the concern of the applicant, my lord, H.K. Das. The matter be taken after Bihu, my lord.
For that, you have not received your instructions.
I have received my telephonic instruction. The committee has been that continued to a committee because large number of persons will come.
You were supposed to file an affidavit.
No, my lord. That instruction.
Instructions, sir.
Instruction. That committee is coming up within 2-3 days, my lord.
Okay.
After
On the prayer made on behalf of Mr. S. Bora, London Standing Council, BTC, item number 29. And with the consent of the Learned Council appearing, amicus curiae appearing for the, with the consent of the Learned Standing Council, Guwahati High Court, list this matter again on
19th.
Let us have it on 22nd. 22nd.
22nd.
May I please, Lordship? Lordship, I'd like to mention item number 1. You may not like to take up this matter.
1 and 2 both. Item number 1 and 2. List before any other bench without me, Munamdu Ligiri.
Lordship.
Wait, please, Lordship. But I briefly mentioned for listing of a review petition ballot that has already been numbered, my lord.
Any mention which is not required for today, please give it to him.
My lord.
May I
Next
please,
Monday, my lord.
may I please, Your Lordship, I beg to mention item number 15. I'm appearing on behalf of Dr. B.N. Gugul, Senior Counsel out of station. Lordship, may I adjourn the matter for the day?
Be here. Let the matter be called up. We will not pass any adverse order, don't worry. But we would like to have some instruction from something from Mr. the Learned Standing Council for the ONGC. Be here.
Sure.
Yes, Mr.
May I
Vishwas.
please, Your Lordship? I may be, I pray for to take care of matters for unlisted at 2 p.m. because an ad hoc has been replaced by another ad hoc.
Lordship, I beg to mention item number 6. In this case, file is taken back, our name may be stuck out.
We'll dismiss it. Be here when it is called. And show me something that your file has been taken away from you.
Lordship, but no document,
When was it taken up? We'll
it was taken back 2 years back, Lordship.
And there, what is there? There is nothing here. Everything has been complied with. Procedure has been followed. Penalty is commensurating. What survives here? You be here when the matter is called.
May I please, Your Lordship? I beg to mention item number 8, Lordship.
8.
I'm not faced this matter, Lordship.
Huh?
I'm not faced this matter.
You want to dismiss it, withdraw it, or not pressing it?
Not facing.
Why?
But it is a 2013 matter. It was a recruitment of the Assam records.
Oh, that. Be here. Let the matter be called up. We'll pass orders.
May it please, Your Lordship? Lordship, I beg to mention item number 4. My learned senior, Mr. C. Sodori, has been hospitalized since 20 of March.
What happened to him?
Excuse me.
What happened to him?
He has several infections, urine infection, and so on.
Oh my.
So,
On the prayer made on behalf of Mr. C. Chaudhary, list this matter again after 3 weeks, or 2 weeks, on a date to be fixed by the registrar. How is he now? He is better?
he is better now.
May I please, Lordship? Lordship, I beg to mention item 20, Lordship. Learned Senior Counsel, Mr. T.J. Moti is out of station. Can you take up this matter on Monday, Lordship? Item 20, Lordship.
Monday.
Monday, Lordship.
On the prayer made on behalf of Mr. T.J. Mahanta, Senior Counsel, list this matter again on 1/4.
Lordship.
May I please, Your Lordship?
Hmm.
Lordship, with regard to item number 1, Lordship may not like to take.
I have already adjourned it. It's already adjourned.
Deeply obliged, Lordship.
May it please, Your Lordship? Lordship, I beg to mention for listing of an urgent matter on Monday, Lordship. Obliged, Lordship.
Wait, please, my lord. Prayer for listing of a matter on Tuesday.
Wait, Tuesday.
My lord, because on Tuesday only 3 weeks will come.
Oh,
At least after 3 weeks.
this mention after 3 weeks is over. Mention after 3 weeks is
No, my
over.
lord, 3 weeks circle will be over on Tuesday, my lord.
Tuesday, make a mention on Tuesday. We'll give it to you on Wednesday.
My lord, there is an urgency also. My lord, they have to bring instructions, my lord, the elementary education department.
Let them, they'll get it. We'll have it on Wednesday. You come,
My lord,
make a mention on Tuesday. We'll have it on Wednesday. No problem. Reiterate your prayer. Let that period be over. Have something. Let that period be over. Who knows? The matter may be listed also. Do you think our registry is not that upcoming? Make a mention if it is not listed on Tuesday.
My lord, item number 33, yesterday we have mentioned that contempt case, my lord. He will be retiring day after tomorrow.
Huh?
Item number 33, yesterday, my senior friend Jay Abedin mentioned.
Item number?
33, supplementary.
Huh.
The petitioner is going to retire day after tomorrow. Your lordship is directed to consider his promotion.
I don't understand what is the urgency here. We have provided for both the situations.
At least
Even
for-
if he retires, Mr. Sharma,
Yes.
even if he retires, we have said that his claim will be maintained as of 1/1/2000.
Malad, they are taking. a
There is
view-
no violation.
Malad, they are
We'll
taking a
dismiss it.
view- They are taking a view that due to model code of conduct, the final. order-
Naturally, they will have to take that view. We can't help it.
At least, my lord,
It is not something they have created.
Yes.
It is something which comes naturally.
at least for one day, my lord, he will get the benefit.
Mr. Abedin, where is the violation here in your case at 33?
My lord,
Where is the violation? The willful and deliberate violation.
my lord, if I want to project, then your lordship will find it, my lord. The only thing
See,
is that,
Mr. Abedin,
what I'm
we
saying,
have taken care of that situation
Yes, yes.
also. Then,
what I'm saying, in the name of, when there is a 15 days order, is a kind of a mandamus.
be that as it may, we have also said that if you can't do it, if you don't do it, but give him at least from 30th.
No, what I'm saying, when.
Okay,
I-
you
I-
argue the matter when it comes
My
up.
lord, when I got the order, don't worry. Day before yesterday, sorry, because code of conduct. Only in the name of code of conduct, that is the only thing, my lord. Otherwise, this man could have said for one day. I leave it to your lordship now.
Mr. We have taken care of that situation also in our order.
My lord, only this, otherwise everything is prepared, my lord. The draft, everything is prepared. Just sorry, code of conduct. So I wanted to apprise this honorable court that code of conduct should not have come in
For a judicial order.
for a judicial order. Obviously, my lord, when is a mandamus within 15 days?
Okay, argue when the matter reaches. Argue when the matter reaches.
My lord, only thing is that if they get the instruction, if
They will not, we will not ask them. Because that order provides, because if I have to ask him, I'll have to be convinced that the order has been willfully and deliberately violated. The order is not willful and deliberate because we have provided for that situation also.
Then I leave it to your lordship.
Then
Yes.
we have provided for that situation also.
Then I leave it to your lordship.
One day sitting, we are concerned with your retirement benefits.
Yes, my lord.
Then
I only that, I also want that only. my lord.
you will get your retirement
And if
benefit.
your lordship,
Let them do that promotion exercise whenever they want to do it. But they will have to do it from 1/1/2000.
Even Malad also indicated that part,
We have already.
indicated that part. And even yesterday evening.
I can understand Mr. Abedin's pressure on Mr. Abedin, but this court will have to follow its orders. I can understand the pressure, what pressure you have on your
no, what I'm
shoulders.
saying, taking care from, saying from that side, what audacity do they have the taking the advantage of
We
taking the code of
will
conduct,
consider, let it be called, we'll consider. You be here.
flow around with the court's order in that manner?
We will consider, sir.
Even Malad Soda is not.
I have not shunted you out. We said we will consider. Yes, Mr. Bhaiya.
My lord, I seek apology, my lord, for the yesterday's incident, my lord.
No, it's okay.
my
No,
lord.
that's a young boy. He has understood. We have
My
made him
lord.
understand.
My lord.
Nothing carried. Whatever he wants to be made understood,
Well.
we have made him understand. That's
Then,
all.
my lord, I
That's
have-
the end of the matter.
My lord, my
You
lord,
can
then-
proceed with your case.
Then, my lord, I have come to know that I am also, my lord, as a lawyer in this case yesterday night, my lord. My lord, what has happened in this?
That happens when a lawyer is too busy.
My lord,
It happens.
actually, my lord, I have not been instructed, my lord, that just.
Okay, fine. Proceed.
My lord, the matter relates to, my lord, selection and appointment of,
Now, just one clarification.
my lord.
If you come to the affidavit filed by the private respondent,
My lord, that is another, my lord, I am out of those pleadings also, my lord, in my record, my lord. Some pleadings are also missing, my lord, so,
can't help it.
my lord.
Mr. Rashid, is this the order which you have annexed against which the writ appeal was filed? Writ appeal was filed against which order?
The VTP
My lord,
Malad, that
We have
order,
stated, my lord, we have stated. at paragraph 9,
There
my
are-
lord.
Paragraph?
Page
Paragraph
12,
9,
page
my lord,
12.
page.
No, you have
Seven.
not stated which writ petition.
Page
my
12,
lord.
can you see page 12 below?
12 of
12 of my affidavit.
your affidavit.
My lord. 5289 of 2009. Relevant portion page 13, paragraph 2nd, 3rd, my lord.
Okay. So it is against that second order
Second order.
which they went. So that is proper. So now what happened? Thereafter, there is an order
There is
of the director.
director. Director had the
Yes,
matter.
what do you have to say on this page? The impugned order, Mr. Bhuyan.
My lord,
Forget
the-
everything.
My lord, the issue is that there is an inquiry had been conducted pursuant to an order of this honorable court.
There is an
That's
inquiry by the deputy commissioner
My lord, that
and there is a very survey report by you,
by myself.
which should be given precedence by this court.
My lord, my lord, to be fair before my lord,
I know that. We know that answer will come from Mr. Bhuyan.
it should be the deputy commissioner, my lord, and my lord. Now the issue is that, my lord, that the deputy commissioner's or inquiry report, my lord, is not under challenge in the petition. My lord.
It's not there.
It's even, my lord, it has not been, my lord, as a part,
Mentioned.
not as a, my lord,
There is no pleading to the record.
my lord.
Okay, Mr. Bhuyan, we'll close it.
My lord,
Better luck next time.
Or my lord, may I pray, my lord? May I pray that one chance may be given to me for take the
No, no, no.
updated instruction.
Enough, enough. This is 2014 matter.
My lord.
After 10 years, no further chances required. Let happen. The petitioner, by way of institute, heard Mr. A.R. Bhuyan, Learned Counsel for the petitioner. None appears for the Social Welfare Department. Heard Mr. A. Roshit, Learned Counsel appearing for the respondent number 6.
Can you do my next one?
The petitioner, by way of instituting the present proceedings, has presented a challenge to the
Termination of the petition, my lord.
to the action on the part of the respondent authorities in terminating her services and terminating her services as Anganwadi worker in number
4, Satchola.
in 146 number Saktola
My lord,
Anganwadi
part 4 Anganwadi Center.
Shaktola, part 4, Anganwadi Center.
Saptola Part 4 Anganwadi Center. Full stop. And the engagement of the of the respondent number 6 against the same. Full stop. The petitioner, in pursuance to a process of selection, was selected as the Anganwadi worker of 8 number Saktola Anganwadi Center wide and order dated 17/11/2009. Also, thereafter, the said engagement of the petitioner was put to challenge before this court by some candidates who had participated in the said selection process, but were not selected for the said post in question. Post op. The said petition being WPC number 25289/2009 was given a final consideration by this court quite order dated 3/5/2011, remanding back the matter to the Director Social Welfare Assam for a fresh consideration of the representation directed to be filed in the matter by the said authorities. Also, in pursuance to the said directions passed by this court, the Director of Social Welfare Assam, while his order dated 16/8/2012, required the Deputy Commissioner to look into the matter and submit his views with regard to the issue pertaining to the residential status of the persons involved. Also, on the report from the Deputy Commissioner being made available, the Director of Social Welfare Assam by order dated 26/6/2013 proceeded to hold that the petitioner hearing is not a resident within the concerned Anganwadi Center area, and accordingly, the CDPO ICDS project Lakhimpur was directed to remove the petitioner from the engagement made in her case as an Anganwadi worker for the Anganwadi center in question and to appoint a person from the same various selection process, appoint a suitable person from the very same selection process. It is seen that the petitioner thereafter had approached this court by way of instituting WPC number
5289.
5289 of
2009.
2009. And this honorable court, where is that order? Ah, I got it.
My affidavit.
When this order dated 5/9/2013, upon examining the matter, was pleased to reject the said petition. Also, being agreed, the petitioner herein approached the division bench of this court by way of instituting writ appeal number 300 of 2013. Thus, the writ appellate court, by order dated 26/9/2013, on noticing that the petitioner, on appreciating the contention of the petitioner that she was not given an opportunity of hearing before passing of the order dated 26/6/2013 by the Director, Social Welfare Assam, remanded back the matter to the Director, Social Welfare Assam to pass a fresh order after giving due opportunity of hearing to the petitioner. Accordingly, the Director thereafter issued notice to all the concerned parties, and upon hearing the parties, including the petitioner and the respondent number 6 in the present proceedings, proceeded to issue the order dated 25/4/2014, rejecting the claim of the petitioner hearing. Also, being agreed, the present proceedings have been passed, have been instituted. Also, a perusal of the order dated 25/4/2014 would also. The petitioner herein had approached the writ appellate court by instituting the writ appeal number 300/2013, raising a grievance that before passing of the order dated 26/6/2013, she was not afforded an opportunity of hearing by the Director of Social Welfare Assam. Also, and accordingly, basing on such contention, the matter came to be remanded back to the Director, Social Welfare Assam, for passing a fresh order. The said order, in pursuance to the directions passed by this court in writ appeal number 300 of 2013, was passed by order dated 25/4/2014. Also, on a perusal of the said order dated 25/4/2014, it is seen that the Director has recorded a finding to the effect that the petitioner was duly heard before passing of the order dated 26/9/2013. Full stop. And accordingly, upon further consideration of the matter and accepting the verification report as submitted by the Deputy Commissioner in the matter, the Director, Social Welfare Assam, proceeded to interfere with the appointment, with the engagement as made in case of the petition. Full stop. It is noted that in the pleadings as brought on record in the petition, there is no ever been made that the findings as recorded by the Director of Social Welfare Assam in its order dated 25/4/2014, to the extent that the petitioner was given a due opportunity of hearing before passing the order dated 26/9/2013, is made. Also, the petitioner's claim is solely based on a survey report wherein she has been shown to be a resident within the area covered by the Anganwadi center in question. Also, it is to be noted that as per the pleadings brought on record by the petitioner, the said survey report is one which is prepared by the petitioner herself after her appointment as the Anganwadi worker in the said center. Also, the Director of Social Welfare Assam, having based his findings in its order dated 25/4/2014 on the verification report submitted in the matter after survey by the Deputy Commissioner, by the jurisdictional Deputy Commissioner, such findings as recorded by the Director of Social Welfare Assam does not call for any interference by this court by making a roving inquiry, exercising the writ jurisdiction of this court. Accordingly, without further examination of the matter with regard to the suppression of facts as made by the petitioner before this court as well as before the writ appellate court, the order dated 25/4/2014 and the consequential appointment of the removal of the petitioner while affected while office order dated 13/5/2014 issued by the CDPO Lakshmipura ICDS projects are upheld. Accordingly, the writ petition is held to be without devoid of any merit and the same stands dismissed. However, there would be no order as to this.
My lord, may I pray for a liberty, my lord?
No liberty. Appeal.
All right, my lord.
Yes, Mr. Sokia, what brings you here?
There is a contempt matter, Lordship.
Contempt.
Contempt.
Which one?
Item 32. The other side may be here.
Oh, Mr. Chaudhary's,
Yes.
MK Chaudhary, that. Oh, yes, that matter.
M. Doctor and J. Bharat.
If you can, Mr. Chisti Brahmazunda, get hold of them.
I said.
Sir, we'll
Let
just
him come.
let him come, we'll ask. Any development, Mr.
I am going to give some students, Lordship.
That will do.
Yeah.
Nothing more is required. You have saved them.
Yes, Lordship. For that only I am here. Lordship.
You call Mr. Aile Mati. Dio, Mati Dio, get to Mati. Item 3.
No, item it is. Item 32.
Yes, no, Mr. Chaudhary is not here. Let him come. Where is Mr. Doctor? He's coming. Mr. Sokia, just have a seat. We'll just go
Yes.
through it first. Mr. Chaudhary is here. He's here. Item number 32.
This cover from there.
Mr. Chaudhary, AG is here.
My lord.
He has some, I think, some breather for you, some good news for you. Yes, Mr.
Yes, Lordship. The issue is now we have to process the proposal for their
First salary.
first salary. So the DDO has said that under the system, 5 documents are to be given. 3 documents, I think they won't be able to give, but the documents just like the bank passbook and 2 others. So 3 documents, I'll just hand over them. Appointment order, joining order, these 2 not required. One is undertaking, instead of police verification, an affidavit is required, bank passport. And medical fitness. These documents, these are in the system of the Assam FinServe. So those documents they have to submit. If they submit it within 1 week, Lordship, then we will take the processing time. Under the system, it takes 6 weeks, but we assure that by 4 weeks, we will be able to do.
Mr. Chaudhary, let's give
These
them a
documents are very easy documents, and these are required, Lordship.
But you see, writing like this that a police verification report is required, it does not show the authorities in good color. In that last
Cannot be in the system, my lord.
no, Mr. Sakia, when they write that this document is required, how can he produce a police verification report?
No, that's what,
what,
in lieu of that, there is a.
but that was not disclosed to this court. That was
Now,
not placed.
this is the system generated document.
When it was placed before me,
Yes.
this was not there. And that is specifically why
And
we,
even bank passbook was not required.
not there. Those things they can give.
They'll
have to
that's why
give.
these are very easy things. One is medical fitness certificate, one is bank passbook.
Can you give me the list?
Yes, Lordship, with this highlighted. No, no. Lordship, may I be pleased to go through the second paragraph. It is stated that BO Lahorighat is the concerned DDO for initiating the first salary proposal of the petitioners through fins.assam portal. But in reply to the letter under reference,
Only you require a notarized affidavit in lieu of a police verification report, bank passbook that first
and
page,
medical fitness.
and medical fitness certificate. Okay, what do you say?
My lord, I'm not sure, are they requiring the appointment letters, my lord?
Appointment
No, no,
orders
no, because they are all regularized.
regularized, so they don't want, fine. In persons to the order dated, so you have deferred my first drawal of
Let
contempt
it
proceedings.
come after 6 weeks. In the meantime, lordship, the things will
You,
progress.
yesterday night, I was pondering over this file, how to draw up a department, contempt proceeding. I was just formulating all those things. But thank you, you have deferred it. Mr. D. Soike, learned Advocate General, Government of Assam, has entered appearance on behalf of the respondents today and submits that due to a misunderstanding, the communication dated 21/3/2024 was placed before this court, requiring the petitioners to provide for the documents as mentioned therein. Mr. Soikia has submitted that as per the required documents for processing of the first salary of the petitioners in the portal, that is the portal of the finance department, known apostrophe fin.assam portal, apostrophe close, comma. The petitioners are required to submit a notarized affidavit in lieu of the police verification report, along with their bank passbook and a medical fitness certificate. First off, it is the assurance of Mr. Soikia that on submission of such documents by the petitioners within a specified time limit, the respondents would process the matter thereafter within a period of 4 weeks at the maximum.
No, lordship will, once they submitted,
After they submit.
after that,
4
the
weeks.
system says 6 weeks. The system says
Okay, we'll put it 6 weeks, no problem. 6 weeks. 6 weeks. We'll process it within a period of outer limit of 6 weeks from the date the such documents are submitted by the petitioner. Mr. M.K. Chaudhary submits that the petitioners would submit the documents which are mentioned here in above. In the order itself, we have mentioned within a period of a week from today, within a period of week from
To
today,
that
before the
block elementary education officer Lahore.
before the block elementary education officer Lahorigat. The block elementary education officer Lahorigat on receipt of such documents will give a due acknowledgement to the petitioners of this thing. Full stop. It is expected that within the time frame as prescribed herein above and assured by the learned time frame prescribed herein above, the first salary of the petitioners would be processed and their arrears thereafter would also be released within a reasonable period of time thereafter. Full stop. List this matter again after
On 16th of May.
16th of May. 16/5/2024 for further consideration.
My lord, one thing may be clarified, my lord, the medical, the certificate has to be obtained from which authority? That may also be, my lord.
The medical certificate be obtained from the.
As per the norm, the BO will inform them.
No, we'll prescribe an authority. I think it's in the district level. What is that officer? Mr. Gogoi. Mr. Gogoi, what is that officer in your there? Medical hospital, we call it?
Chief medical officer.
No.
No, well, that is the authority of the social welfare department. There is a medical board, well,
No. This is only medical fitness, not a board, medical board.
There goes the joint director.
Huh?
Joint director of that particular district, they will well provide it after examination.
It is required that medical fitness certificate issued by the government medical authority. So the district level medical officer.
Medical doctor, the medical certificate, medical certificate as noticed here in above required to be.
Or
fitness
Morigaon
certificate.
Civil Hospital, the superintendent.
Full stop. The same would be obtained by the petitioners from the superintendent of the civil hospital of the
Morigaon.
locality.
My lord,
Yes, Morigaon.
Let it also not be delayed, my lord, there in the medical certificate also, my lord, that may be immediately issued by them.
Full stop. In the event the petitioners approach the superintendent of medical of the civil hospital, Morigaon, they will furnish a copy of this order to the said authority. The said authority would issue the medical certificate upon due examination of each of the petitioners within a period of 2 days from the date of such appearance by the petitioner before the said authority. I'll put it next. I think now the issues would be resolved.
He is always a problem solver.
He is,
No, problem, it will be solved temporarily, definitely.
but thereafter, you know what?
Yes,
But we are only concerned with our.
absolutely, absolutely. That is
And
what I was telling them.
Mr. Srikia, have you read this? Communication
No,
that
no,
was placed. And thereafter say whether we were wrong in passing that order.
Because after Supreme Court's non-interference, then nothing remains. This is
Nothing.
what I told.
Thank you.
Highly obliged.
I'll just put it in seriatim and then I'll get it. Item. Yes, item number 3.
May I please your lordship, may kindly pass over the matter for the time being.
Okay, who is appearing?
Mr. Mukesh Sharma
Okay,
for bank.
we'll hear Mr. Gogoi in the meantime. Yes, you sit, you take notes.
Well, regarding my lord, the order of penalty, my lord, of compulsory retirement, my lord, in a DP held against the petitioner who was working as a my lord, head
What happened to the criminal case?
criminal, my lord, he has been acquitted.
Where is that order?
That part, my lord, in fact, a final report has been submitted to my knowledge, my lord.
So that will have a bearing here.
My lord. That's for my telephonically I was informed.
Can you get that?
I
Get a
will
copy of
try.
that order?
Yes,
Because basically it's a factum of loss of that money.
loss of money.
Because naturally there was a case that you had defalcated the money before the police.
Lordship,
Now, if they have not found anything against you, that you have not,
lordship.
and the only lacuna I find here is that it's a presumption that you have, they don't say defalcated. It was misplaced or because of your negligence it went.
In negligence part, my lord, yes.
So-
In fact, the FIR also, my lord, lost by them. They have only alleged that, my lord, money is
Negligence.
lost from the bank.
Loss from the bank.
And
So
within half an hour
that's
it has
what
happened.
we find here.
My lord,
So if that is there,
lordship.
maybe we can consider that also.
I-
But
I
he will not
apply.
get back his services.
That part, of course, my lord. Only thing, my lord, now, my lord, after deducting those, my lord, 5 lakhs.
We
he
will
has got
only
that-
go, we will go to the extent of protecting you to the extent of recovery of that 5
I
lakhs.
will be obliged, my lord.
That much
I
only,
will be obliged.
that much only, nothing more. When? Monday?
Monday.
List this matter again on 1/4/2024. Compulsory retirement will stay, but that 5 lakhs we will.
But
Say
in
no
fact, my
recovery.
lord,
And you also get me that PF, I think PF Act also provides for certain circumstances under which
my lord,
recovery,
they have a act, my lord, their own.
their own act,
Yes,
that staff regulation,
yes,
staff
my lord,
act,
yes. Only thing, my lord, can it be kept as part or further hearing, my lord? Only
for further hearing.
my lord. I will.
1/4.
Your lordship.
Yes, we have need some instruction from the petitioner. Can you
Huh?
pass? Need some instruction from the petitioner.
Okay, I'll provide the instruction. You continue.
I have not,
Para 9 is your pleading.
we have need some instruction.
You can't have any instruction. Instructions are all here. Continue with your arguments. 2014 matter, you want to withdraw it?
No,
Then
my
you
senior
hear.
instructed me to say this.
Huh?
Senior instructed me to say. this.
Huh?
Senior instructed to me.
You are tell your senior that is not accepted by this court.
Can they pass over the matter?
Time being.
For,
Huh?
for the day.
No, no,
Later, any other day.
no, today itself.
Sir, we have not able to contact. with
You
the
forget it.
petitioner.
You don't make any arguments. We'll ask the respondent. 2 questions. What is CTBT? What is the full form of CTBT? Comprehensive Test Ban Treaty. Comprehensive Nuclear Test Ban Treaty. So where is that mistake? 1 mark gone. Then second one, RNS, X and Y. Who is X? Who is Y? It only has to be the uncle. So 2 marks gone. You're out.
Can pass over for
No.
the day? Can
Time being I can do it, but not for the day. I can give you time till 2 o'clock. Not beyond
we
that.
pass over for the day?
No. 2014 matters until and unless you are medically unfit, this court will not adjourn. 2 o'clock. And if you don't come, we'll dismiss it for today.
Lordship, in this case, we are, petitioner has taken back the file. Lordship, may I record my submission in the Lordship,
when did he take the back?
it was taken back 2 years back, Lordship.
The Mr. L.R. Majumdar, Learned Counsel for the petitioner submits that the petitioner had taken back the brief from him and accordingly he is no longer involved in the said matter. Full stop. It is seen that there is no further engagement of any counsel by the petitioner in the matter. Accordingly, the writ petition stands dismissed for non-prosecution. Interim order passed early. No, interim order there is no. interim. Mr. K.R. Parasa.
K.K. Parasa.
K.K. Parasa appears for the
Yes,
union, CGC appears for the respondents.
Obliged.
Other than adjournment, ask for anything.
for a timing.
A time being, no problem.
Lord, may I please, Lordship, Senior Standing Counsel, Gaekwar will appear in this matter, Lordship.
Forget it. Forget it. You be here, that'll do.
Lordship.
2012-13 matters cannot be adjourned like this. Eight adjournments.
I don't want to pressing this.
You're not pressing it. Wait 1 minute. Let it over. Oh, that Bodoland.
Lordship.
You don't have the marks.
Yes. Rejoined.
You don't have the marks. Merely because this court did not direct that they should appoint you. It said that remaining 32 vacancies be filled up in accordance with the law.
Lordship.
So,
But-
okay,
but-
you're not pressing it, fine, no problem, we'll not bring it. But Mr.
DC now.
DC Nath, Learned Counsel for the petitioner, and also Ms. P. Sharma, Learned CGC, appearing for the respondents. Mr. D.K. Nath submits that on instructions, Mr. D.K. Nath submits on instruction that the petitioners do not wish to press the matter any further. Accordingly, the writ petition stands dismissed on withdrawal. Full stop. On withdrawal. Move interim order.
Matter relating to termination of service.
Only one thing you satisfy me,
Madam.
forget the rest.
Madam.
You come to the medical certificate.
Madam.
Show me the head. We have the tail with us. Show me the head. Show me the head. You have the tail with us. Page 51.
When he went to the,
When he went, what was his condition? Where is those documents?
at that point of time, my lord, I did not expect this to come. My lord, Lordship will have it on the reopening. I'll have all the medical.
I think I have been giving you this
No, my
opportunity
lord,
for
on
the last
my lord,
around
only-
how many?
My lord, only.
25-1,
No,
8-2,
my lord.
5-3.
Lordship will, this question has fallen for the first time.
This question is there when you have annexed this document,
My lord,
51.
I had given
And you come to
Yes.
page 52.
52.
Huh?
My lord.
What is this certificate? Who is this authority?
My lord, this.
He is a subdivisional medical and he is saying that somebody else is treating him.
He's, Lordship will find the first certificate at page 50.
I got it. First certificate, private
Yes,
doctor.
it has to be.
No head,
My lord,
no head. Because if it's tuberculosis,
Which,
where this first certificate,
my lord, that is what I'm saying. That is what I'm saying.
27, 2011,
Since Lordship is.
you have not produced any of this certificate, Mr.
I was, that has not been produced, my lord. That has not been produced because these certificates have come after the dismissal order. It could not have been produced at that point of time. Petitioner has made. the
13, 12-3-13 certificate.
Yes, my lord.
Then the other certificate, 14-3,
Yes,
2000.
these are both after the dismissal order.
Then,
After
then
the.
how can we give any credence to this?
My lord, even if it is, even if Lordship allows me, I can produce the original medical record. This is a TB.
We will not permit you.
My lord, this is a TB. My lord, TB is a disease where records are kept. for the hospital.
You had that with you. You were on leave.
Yes.
you had this disease,
Yes.
you could have just sent that certificate to the authorities. That would have been the end of the matter.
True.
Now
Even
today,
in that case,
after the dismissal order,
even in that
there
case,
is a doubt because they have not had an opportunity to examine
now,
this.
there could be two options on this, maybe. One,
There's only one option, dismissal of the writ petition.
if I can just show that there is some discrepancy in the inquiry and that these factors come
We
to light
will
and
not
we need to-
permit you because that discrepancy, you were given full opportunity to appeal.
That full opportunity is not there is what I can show, man. Even by the rules, that opportunity was not there is what I.
You're
can
not
show.
entitled to the technicalities. What prevented you?
That statement is there that I was under medication, my family did not give me the documents. That is the only a stand which is true. I cannot invent
Okay,
a stand.
the family is suffering now. Fine, that is the result. That is the result. Why should we come in?
Lordship should come in because if there is a fault which goes to the root of the matter, number one, and
See,
number
there
two,
is
he had
no
to have a-
material even on record of the writ petition to show that you were not in a position with effect from 27/2011.
Lordship will only see,
Because
they asked me to, the letter sent to me, they asked me to
We,
appear on a date prior to the
we
date
don't
of-
know where this Dr. Jayan Talukdar is.
Lordship will give that, those are
And
facts which they
see,
can verify.
the TB center here,
My
I
lord.
don't know how they have
No,
issued this
the
certificate.
the TB center here, my lord, the TB center here being the state center, the records have to come here, the certificates are given by the
And
district
see,
which are verified.
you were not
and-
suffering from TB of the lungs.
Yes,
You were having intestinal TB,
which is a rare form.
very rare form. But where is the material to show that you were not even in a position to communicate?
My lord, whether that,
How long were you in service? When did you join your service?
my lord, I joined my services
2001,
2000.
10 years. So you know the ins and outs.
I mean, that is not the issue.
Yes, Mr. Gugoi.
She just rightly indicated that part. I also
That is, forget it, that I am indicating to you. What do you have to say?
Lordship, that order was passed on 17 July 2012, Lordship.
Now tell me one thing, he is missing. What steps did you take? Did you go to his house
Lordship
to
already.
find him out?
That part,
Deserter.
Lordship.
Before that, apprehension roll has to be issued. Was it done? Was the police informed?
Lordship, notice was issued, Lordship. That part is there, record is also there.
What is there in the record? Any communication from him within this period?
No, Lordship.
Nothing.
Nothing is there, nothing.
And see whether the show cause notice, enquiry report, all those things were furnished to him.
All those things are in his address, Lordship.
No, just see if there is any acknowledgement to that.
Lordship, in his postal address, Lordship.
Hmm?
Postal address.
Postal address.
Postal address, in that regard, our High Court judgment is also there. on the
That
same-
once it is sent, it's gone.
Same issue, Lordship.
Supreme
Even-
Court judgment says otherwise.
Same issue.
Supreme Court judgment, there are otherwise.
Supreme Court, in that fact situation, fine, but here,
The date of my appearance is prior to the date of the issue of the letter. Those technicalities are there, which even if I had received, could not have.
Tuesday. On the prayer of Mr. R. Mujumdar lists this matter again on 2/4/2024. Mr. Gugoi, go through it,
Lordship, Lordship.
find out what is the manner in which you drew satisfaction
Lordship, Lordship.
that these were given to him.
Lordship,
Just show me that.
Lordship, Lordship. Also, instead of Tuesday, Thursday,
Thursday, no problem.
Thursday,
Fourth,
Thursday.
for further hearing,
Lordship, Lordship.
for further hearing.
Lordship, Lordship. Obligation.
But just go through the records,
Lordship, I'll.
only on that aspect.
Obligation.
That I fixed to the point of.
There's 65 lordship.
Yes, what is your submission?
My lord, rule 27 of the my lord CRPF.
Show me. That's the only submission?
My lord, does not permit my lord.
That
deduction-
Rahul Kumar's case you want to rely on. You
Other
want to
than-
rely on Rahul Kumar.
My lord, other submissions are also there lordship.
Continue.
Then,
Give me everything.
my lord, honorable single judge lordship.
Hmm.
My lord, set aside the, my lord,
penalty passed, my lord, by the authority, lordship.
When?
And on the ground, my lord, the one was, my lord, set aside, my lord, the murder was, my lord, employee, lordship. That was, my lord, set
Now
aside.
you come to
Only
page
one, my lord.
65.
One,
Page 65, that is the penalty.
yes, lordship.
What is the mistake there?
My lord, penalty, my lord, clause 7, clause 8, lordship. That's
Clause
65,
it. Okay.
clause 8, lordship. My lord, this is highlighted. Reduction of pay by two stoppage in time scale of pay in the revised pay scale of
CRPF Act.
CRPF rules 27, lordship.
CRPF. Yes, then. So reduction by 2 stages in time scale of pay in revised pay scale of corresponding pay scale so and so for a period of 3 years with cumulative. What is the mistake?
My lord, as per rule 27, there is no provision, lordship.
Okay. 1. Rule 27 violate. Next.
My lord. Now 72, lordship, rule 72.
72. Asa? You have a CRPF Act.
Yes, sir.
So, the rule 72, yes.
Withholding in increments only, lordship.
Huh?
This, my lord, withholding of increments, my lord, this is not reduction of pay, lordship. My lord, only rule 27, my lord, there is no provision of, my lord, reduction of cumulative effect, my lord. In our case, my lord, in my case, my lord, cumulative effect is given, lordship. My lord, settled by the honorable court, lordship. In the case, my lord, 2 cases, lordship. One is the 2018 5 GLT 544. That is Rahul Kumar, lordship.
Just a minute.
Copy this. That copy this. Awesome. Itu program tu dia. Program. Matu kan.
Mr. Chakoti, where is that penalty is prescribed?
But 27(3), madam.
27.
Rule 27.
Rule 27.
Sub rule 3. Reduction of pay. To a lower stage of pay.
Reduction to a lower stage in the cell for a specified period. Okay. Yes.
My lord, Rahul Kumar case, lordship, paragraph 14, lordship. I have given, lordship.
Page?
My lord, paragraph 14.
14.
Yes, lord.
This will not be applicable to you.
My lord, 27 does not permit, lordship.
27 permits.
My lord, here in this case, my lord, 27.
There is another man looking very anxiously here.
My lord, in the
Somebody
case,
is very anxiously, the ears are here. He knows it.
my lord, in the other case, lordship.
Yes, Mr. Muzumdar. Stoppage of increment with cumulative effect, debatable. But reduction in rank, reduction in time scale permissible.
There is a separate punishment.
You come to 27.3.
My lord.
Rule 27.3.
I see, my lord. 27, he only, my lord, it does not say about the, my lord, reduction of, my lord.
Reduction to a lower stage in the time scale for a specified period.
Specified period, lordship.
Here you see, it is 3 years.
See, my lord, reduction to a lower stage in time scale of pay for a specified period, my lord. Cumulative effect, cumulative effect, my lord, this is not a specific.
May
My
not
lord.
be.
My lord, nothing
Can.
says about this cumulative effect, lordship. That should be there in the, my lord.
Once it is reduction in pay, and you were referring to rule 72,
Now 72 lordship. This is increments as regards.
that is different.
Nothing about lordship, the reduction of pay, lordship.
Yes, Mr. What reply do you have?
There's no specific bar, madam, under 27(3).
Hmm,
It already mentions for a specified period.
hmm.
There's
That
nothing-
takes into account everything.
Yes, ma'am.
Yes, Mr. Majumdar. Reduction to a lower stage in time scale of pay for a specified period. So that need not also have with it cumulative effect. It automatic.
What I would suggest is withholding of.
Any pending matter? No.
My lord,
Any pending matter in this line? No. Then you argue.
withholding of an increment is I remain in the same scale. I do not get my next increments. I stay there.
Here,
With cumulative effect would mean that I would start again when the punishment ends. And reduction would be when I'm brought down from
To
my
two
pay to
stages.
the whatever
that,
stage, one.
for
to two
that,
stage.
you don't require
So withholding or
for
reduction.
bringing down in the pay scale, this word cumulative effect is not required.
My lord, it can still be there.
It can-
Because once the reduction is without cumulative effect, the moment for a year. If it is for a year, then I go back to
To
what
that
I
same
would have
place.
wanted. Yes. And
But
if it
here
is
you will go
without-
back, you will be there.
I will be there for the 3
3
years
years.
and then I will start at what I would have got 3 years ago.
Okay.
If it is with cumulative effect. Therefore, my lord, in that Punjab case, Punjab Electricity Board case, Supreme Court has given that difference. What is cumulative effect and what is not cumulative effect? If it is cumulative effect, then it goes up to my pension also. If it is not with cumulative effect, I lose it only for a year or 2 or 3, 4, 5, whatever it was the term given. Therefore, my lord, reduction and cumulative are two different punishments which can be imposed upon me. Firstly. Secondly, my lord, what I had argued on that day is if the punishment itself is not there, what Rahul Kumar has said, if the cumulative part
Punishment is not there.
if the cumulative part is not given, the power of cumulative.
But here,
Effect is
if
not
you
given.
read 27(2) and 27(3),
27(2).
2 and 27(3),
27.
2 and 27(3).
27.
Rule.
Huh?
No, the penalty is prescribed. 27(a).
27. Yes, on the table, my lord, it is a reduction to a lower time scale of pay, grade, post or service. When we are reduced.
You are reduced.
Yes.
1.
And 3
Next
is
one.
reduction to a lower stage in the time scale of pay for a specified period. So that reduction has to become, that reduction did never come. Now lordship would find 7, it is stoppage of increment. It can only be a stoppage of increment. So that cumulative part.
No, here whether
Unless
in
authorized.
2 and 3, whether the cumulative can be read into.
My lord, even this cumulative cannot be read into for the orders of the honorable judgment of the Honorable Supreme Court, where it says that since it's a different punishment, it will go from a minor to a major. So it is a higher punishment. That higher
No,
punishment is
this
not
man
given.
is regularized.
The lordship will find if the moment cumulative is introduced, it becomes a higher punishment, a different punishment, a major punishment. Without the cumulative part, it is a minor punishment, specifically stated by the Supreme Court.
Okay.
Therefore, once that major punishment part is not, the power is not given, that will not be applied, was the argument. Obligement.
So it will be till 3 years, but that with cumulative effect is the
That part
debatable.
goes- So he loses his increment for 3 years only.
Loss.
Otherwise, it becomes a major punishment, which is not where the power is not there. Obligement.
My lord, now, my lord, clause 8 is very much clear, lordship. It affects also, my lord, increments, lordship. Next sentence, lordship.
That is there. That you will not earn. Once you are brought down, you will not earn. Otherwise, what is the meaning of that penalty?
Lordship.
Yes. Sorry, Gary, what do you have to say? Only on that point. Others, Forget it.
So far as one community part is concerned, though it is not mentioned here specifically, one. Under 27(3) says for reduction to a lower stage in the time scale of pay for a specified period. So for a specified period is 3 years.
3 years, but whether it will be with cumulative effect. Examine, we'll have it on
Yes,
Tuesday.
yes,
Tuesday, I'll also examine.
yes.
Tuesday.
Lost.
Otherwise, that part will go.
Other aspect, Lordship, I'll also.
Other aspects, I don't think so. After the order of this court,
Lordship.
only this much, you have got a breather. Now, only thing we have to see is whether with cumulative effect, these 3 words will remain or not.
Lost.
Okay?
All right.
List it on 4-4. 4-4.
Hmm.
On the prayer of the parties, list it on 4-4 for further hearing.
Yes.
All right.
Who is appearing, Mr. Chakoti? You are appearing. Now, tell me one thing. He says that the post, there is a difference. He refers to this post as superintendent mechanical or something.
No,
Radio communication
From radio mechanic, I become a chargeman signal.
signal.
The finance commission or the payroll say, the revised payroll say that for any post which requires a diploma.
That's what
will
I'm,
become,
that's what I'm,
there is a certain pay.
that's what I'm. They have filed an affidavit here towards the end of that. They say chargeman signal is 100% promotional and there is no element of a diploma there.
My lord, it is,
Just show me that.
their recruitment rules will show that
Show
there
me.
is an element.
Because their specific statement is to that.
And I'll get to the recruitment, my lord. Lordship will have page 42, a bit unreadable. But Lordship will kindly have. page
Naturally,
42.
that will not be
No,
readable.
the type copy is there, but there was a wrong typing, therefore I'm not referring to it, madam.
That's what.
There was a wrong typing.
Mr. Chakravarti, you should have caught hold of that.
Lordship, I have a copy of the
Rules. Give me.
1982 rules and the
1982
and
and
the 2015 also, Lordship.
1982 is what I'm referring to, my lord.
82 because it's 5th CPC in 2006, right?
Yes.
So before 2006, there was no amendment. Amendment came in 2012, I said.
Yes.
12. So 6 CPC, that amendment will only fail.
Yes. Lordship will have page 42.
Yes, the rules are here.
My lord, page 105. Is what? Perhaps I need that 105.
Chargeman signal.
Signal, subject to variation dependent on workload. Then group C so and so. 5 is selection. 8, between 18 to 25 years, relax, 18 to 25
3
years.
years
has to be-
recognized diploma licensee in
Column
electronic
number 7 will be
Essential.
relevant.
Huh?
Column number 7 will be relevant, Lordship.
Column number 7,
relaxable
3
transfer
years
with
recognized
the crucial
diploma.
data determines so and so, so and so.
So
so.
diploma is there,
License.
and then Lordship will find at column.
Yes, Mr. Chakravarti.
Lordship is Lordship, the length of experience also there, Lordship. 1 year. In case of charge mechanic, Lordship.
No, not on that. Because it says 3 years recognized, so that
Diploma.
there is a diploma attached to that post.
Yes.
Now,
Then
why
lo-
do you say
Lordship-
in your affidavit?
Lordship will have 8 for a moment. 8.
Yes.
That
Column
is-
8. Column 8, madam.
Promotion,
For promotion, it is age, no qualification.
right? Radio
No, but
mechanic,
As 11. From
same
radio
as
mechanic to
charge
charge
mechanic and those things it will come.
Charge signal, charge mechanic, everything same, then Lordship will find at 11.
But what I'm concerned is
Yes.
your
The-
principle, your plea can be accepted
Ah.
if there is a direct recruitment
Yes,
element.
number 10.
Exactly,
Lordship will have
Lordship.
10.
Exactly.
Just a moment. If there is a direct recruitment element available and a diploma is prescribed,
Yes,
then automatically the direct recruits as well as the promotees,
all coming.
because it's my own promote, that will automatically come in.
Column 10, Lordship will have
Promotion failing which?
from the army, so and so transfer, and failing which by direct recruitment. The direct recruitment element is there. Anybody who's brought in direct will have to come with that. Column 10. The direct recruitment element is there. So simply because we were all promoted, we have been denied it. But
No,
the direct recruitment element is
but
there.
they say,
Para 20, Lordship. Of our counter affidavit.
counter affidavit.
Last sentence, there is no direct recruitment for the post of charge.
Why?
Because we have followed 100% promotion.
So there has to be some notification somewhere. Because your rule says provides for a direct recruitment,
Lordship,
right?
now whether that can be debarred us from making the 100%.
No. See, once the rule says something, you can't go beyond. You will have to amend it. You have the 2012 rules with you. Right, Mr. Majumdar, it boils down to that. If there is a direct recruitment element, promoting
So therefore,
Vishwakarma, everything comes in.
if none of us were eligible for promotion, it had to be a direct recruitment. That element is there in the rules.
No,
Promotion-
that's what we
Now
want to
they
find out.
got, no, the rules say so. Now they got us promoted. They have filled up all the posts by 100% promotion. Everybody was promoted. That is something which happened in service law. But failing the promotion, the
We
element
will
of
have to
recruitment is there.
understand why that was done.
Why everybody was promoted. Because
Because there is no direct recruit here.
Lordship, page 106,
Hmm.
column number 10.
Promotion failing which, no,
That is what I'm saying. That promotion failing which by direct recruitment, the element is there.
But whenever,
Direct recruits need not be there. That is what Lordship's judgment has also said. It is related to the post, not to the
no,
particular incumbent.
no.
It cannot be to the incumbent, it can be to the post.
It's to the post and it is promotion.
Yes, so
There is no direct recruitment here.
then my case will.
all the options are
You
open to us, Lordship.
come to para 10.
Para?
10. No, that clause 10. 106.
Then it goes, madam, then it goes. Then it goes.
And read for me the last two words for Mr. Chakraborty. Anyway, you have closed your file. Why should we go into that? 106 you don't want to read. Clause 10.
No, I was, when Lordship.
That
was
page
saying-
106.
The page, yes. No,
And thereafter close your file. If you want.
need. Then 6 years. Promotion failing which
Last two words.
from the army on posting or transfer, failing which by direct recruitment. Then failing which by direct recruitment,
Now you close. You have closed your brief.
by direct, failing which by direct recruitment.
Now you don't want this court to proceed any further.
I want my role. I
You
had closed
closed
my
your brief.
arguments. I had closed my arguments. my lord.
That's it. Why do you open your mouth again? Yes, Mr. Chakraborty.
Lordship, there is a specific provision. We can fill by promotion.
No,
also.
if it is, there is a direct recruitment element available, then diploma comes in. And if
If the
diploma
option-
comes in, they're entitled.
If the options are open to us,
He
Lordship.
is entitled only because of the
No, Lordship,
directions
in
of
the
this.
case of overseer and all, there is a marginal Lordship. There is a.
There is a provision for direct recruitment and promotion.
No.
You come to overseer.
Come to.
Overseer.
So the 2024 judgment by the Punjab and Haryana. Exactly same.
Direct recruitment, promotion.
Overseer, Lordship.
Now, Mr. Chakraborty, can you just have an instruction as to whether all times under the 82 rules, there were never a direct recruitment, it was all on promotion. Why?
We have stated specifically on paragraph.
No,
20.
I know, I want to know why.
Okay.
Why? That's the issue, Mr. That's the answer.
And
If there is a direct
in any
recruitment
case,
element,
One thing only. The direct recruits will come in when there are no promotees.
Lordship, even
How-
if
Whether
that
to
is.
fill up all the posts or not is the prerogative of the
because
department.
that's the way it is provided for.
Yes, so they want to, out of 30 posts, they want to fill up 20 posts for the day. 20, they are fine, ready to promote, they promote 20. So there'll be no direct recruiter, no direct recruitees. It is at their mercy whether there is a direct
No,
recruiter or not coming
It's
in.
not there at their mercy.
Only when
Because
someone-
they say that it will be filled up by promotion only.
Cannot do.
In the event there is no promotee available, army.
Exactly.
Army also not available, then only direct.
Direct.
recruit.
So the
So
element
that
of
is
direct
the
recruitment
distinguishing
is there.
factor between
Direct-
Vishwakarma, Pramod Singh and this
But
case.
Pramod Singh also, if lordship will find the same recruitment rules would come in.
Charge mechanic.
Yes, the same thing. If I'm not mistaken, I don't know. whether
Just show me that.
I have just annexed it or not, that part I forget, but that part was there.
No, you don't forget. Never. It doesn't come to your mind when it is not required. Come to charge mechanics. Page 87. Mr. Chakraborty, give him that, please.
Charge mechanic,
10.
then direct recruitment 25%, failing which by promotion, failing which by deputation, transfer, so promotion 75%. So 75% promotion is always there.
But direct recruitment is also.
The direct recruitment, no, in that.
Read further. Don't
Yes.
stop. Read further.
Failing which from the army posting and failing which by direct recruitment. So this direct recruitment is also for that 75%. 25% they will have to take in as direct recruitment. Here, unless the 25%
But
is not there.
Mr.
Ultimately, the direct recruitment is there.
Mr. Chakraborty,
Lordship.
once you have denoted that the post, if it is direct recruitment, will require a diploma.
Yes.
That means the recommendations of the fifth CPC and the sixth CPC, to that extent, it says any post wherein the minimum required qualification is diploma, 5,000, 9,000, and 9,300, 4,200. Right?
Lordship, even if that be so, Lordship.
Lordship will have charged by electric, it's all by promotion, they have given it to them.
Lordship, it's all, it is open, always open for the
Chargeman
employer.
electric, any order of this court?
Chargeman, everybody was covered in the Vishwakarma.
No.
That
That was chargeman mechanic.
This
Because
Lordship
Lordship, the
will find,
post of child mechanic overseer, that has been merged, Lordship.
No, fine.
That
Lordship will find it
I have
page
annexed that,
Page
88,
88.
page, this one, this recruitment rules that he was referring to. 88, Lordship finds.
Charge
88,
electrician.
Charge electrician, next page, page 10.
Okay, now show me the order of this court covering charge electrician.
Lordship will get it sometime, my lord. I did the charge electrician, I'm sure.
You get it.
I-
Mr.
I
Chakraborty,
have
if that is be so, then he has a case.
I have got.
After some time.
After some time,
after
I'll
some-
get it, madam.
You come by two. Come by two.
at two, Lordship.
Two.
It will come.
As Mr. Majumdar closed his brief, we'll not pass a mandamus. We'll leave it to you.
But she will not take that. I had concluded, my lord.
And it is case of may I pay a little accommodation, my lord, let the matter be taken up either on Monday or Tuesday.
Whenever it's convenient. to you. We'll have it on Thursday. Convenient? On the pre-made by, on behalf of the Learned Council for the petitioner, list this matter again on 4/4/2020. 4 will be converted, you want a bit more? Oh. Mr. Das. Mr. Das. We will not trouble you today. This court asked him to be examined by the medical board.
My lord.
This court required him to be examined by the, that's the case, I suppose.
No, madam.
No, not, it's not.
No, it is my lord.
Oh, that policeman.
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 Security
can you,
guard,
Mr.
security guard, my lord.
We'll have it on Thursday. How can you, Mr. Roy?
No.
Once you have given him a certain terms and conditions, subsequent things coming to, how can you? We'll have to allow this.
That is only financial benefit, my lord.
That much only.
I feel it. Let it be on Thursday, your lordship allowed that on Thursday.
Thursday.
It's better.
Mr. Das, we'll allow it on Thursday.
I have also seen that, my lord.
You can't.
No, I know, madam.
Public.
Thursday. Yes, Mr. Deka.
My lord, the subject matter of challenge is that promotion policy, my lord.
Your case is
Yes, my lord.
at page
At
10.
page,
Okay, 9 also.
page 60 of the resolution part.
Come to page 9,
9.
para 50.
Yes, ma'am.
Your case is that the similarly situated 3 persons were given promotion from 1/1/2013,
Of that particular.
right? And you were given from 1/1/2014.
Next time.
So 2 clauses of the permission policy, clause 6 and clause 7,
Yes,
right? Which you say are contradictory.
Yes.
Now, if you read it harmoniously, they say that 3 years is the residency. But any person who completes 3 years from January to May,
January to June.
they will be promoted from the first of the year of that.
That year.
And from July to December, whoever is appointed or completes, they will be promoted from,
Next year.
what is the error?
My lord,
You were admittedly appointed after the selection process was over.
yes.
A decision was taken by them that they required further 2 persons. 2 posts were created. You came in subsequently. If somebody had put that to challenge, your appointments would have gone. Because those were future vacancies, not covered by the initial recruitment process. Now you came in October, in November. You can't better that date.
Yes, this is my date.
You can't better that date. You will have to remain there. What more is that?
But my lord, we have been appointed pursuant to the same selection process.
Self-selection process, come to their affidavit.
They have not replied.
Para 5, there is nothing here. You have not presented a counter to this. Para 5, page 80.
And second letter is page 9.
In the meantime, 2 additional posts become required in the organization and series. There are already 2 candidates. Petitioners were there, the local managements got approval from the competent authority for filling up these 2 posts by 2 panel candidates.
By creating additional posts for them.
Page 9.
In the advertisement, my lord, no post was.
Second letter is page 9, additional member. Lots of documents is page 9.
Page 9 of your affidavit. Your affidavit.
Yes.
And
And they have,
you come to page 6 of that affidavit.
Yes.
Serial number 1, 2, 3, normal selection. They completed it 3 years on 1/6, 31/5 and 2/6. So in terms of that policy, they got promotion from 1/1, 2013. You were appointed on 30/11/2010
Yes, ma'am.
and 13/12/2010. You get it from 1/1/2014 in terms of that.
Yes.
You have not alleged that you should have been appointed ahead of this 3. There is no allegation.
There is no allegation against them, my lord.
Then-
There is no allegation against them. But my lord, at the
Your
final-
seniority is not disturbed. Seniority follows the same
my lord,
as it's here. It's there. You won't have it from 1/1/2014 until and unless you make a challenge and get that clause 6, 7 set aside. 6 or 7 set aside.
6.3, my lord. My prayer is to for setting aside that clause, my lord. 6.3 at page 60.
No,
6.31.
no. Your challenge is to 6.3 because of 7.
Yes, my lord. At my lord, at page 6, my lord, that filed by the affidavit. On that date, my lord, that was serial number 1, Subrata Bharta.
Hmm.
On that date, my lord, he completed only 2.6 months, my lord.
No.
2 years, 6 months.
That is because of this 7.
Rule 7.
No, 6.3.
Yes, my lord, 6.3, but
The executive completing the span period between 1 January to 30 June
Hmm.
will be considered from the highest grade with effect from 1st January of the same year.
yes, my lord.
So you say that word span has been misconstrued, but
Misconstrued.
they have construed that properly. They say that's a policy decision. How can we interfere? It's applicable to all, irrespective of cadres.
But my lord, in the advertisement, my lord, no post was indicated, my lord. How many posts they are going to fill up?
They say 3. You have not disputed this position.
lots of 3 posts.
You have not disputed this position. And see, they have brought on record page 9 also. So in that view of the matter, nothing survives.
Next week, my lord. In presence of my-
And lots of they have not challenged their promotion order.
That you forget it. That we will look into.
Can it be next week, my lord?
Today, if you want some time, you can have some time.
That is what, that was my case only.
I don't think so. That survives. After this affidavit and the provisions of the will. And there being no
Well,
pleading
one
on your,
time, my lord, I have
there being
to-
no pleading on your part that you also should have been given an appointment from that day.
That appointment.
And Lordship, page 56, Lordship. Page 56, Lordship, we have communicated about against their
Yes, yes, you have communicated. You have communicated. And they have come making a challenge to that only after that.
All
So, Mr. Deca, let's give it a closure. Anything more other than
My
this?
seniority, I have to compromise my seniority.
You have, your seniority is always already below them. It's not for the first time that you are coming below
Yes,
them.
and I have not questioned that.
You have not made anything and you can't. After this affidavit, wherein it says that originally we only required 3, we got 3, then we required 2 more. Accordingly, additional posts were created thereafter. Now, once additional posts, how could I don't know how they went back to that. Nobody challenged,
Yes,
so
no.
fine.
Lordship, there is a judgment of Supreme Court also.
Not one, there are many.
Yes.
That you can't exceed the vacancies that you have.
Orud
advertised.
Das from Guwahati High Court, Lordship.
Or
Haryana,
appointments-
there is a case.
Appointments. were-
We'll give it a closure. But Mr. Anand Dekan, Learned Counsel for the petitioner, also has Mr. Peter Division. Obliged to dispose of. Move video.
I am obliged, Lordship.
Item. Mr. Deca, you go through it once. I'm here, I'll come back at 2. If you find something further,
My-
come and tell me.
my-
I'll consider.
I'm
But,
grateful.
but by 2, not beyond that. None appears on behalf of the petitioner on call. The petition accordingly stands dismissed for non-prosecution. Last fall at how Kumba ile mati dibo. Yes, Mr. Roy. Here, the matter was referred to, will not pass any orders, don't worry. Matter was referred to the Guwahati Medical College Board.
Sir.
The board opined that he is having schizophrenia in
No.
remission.
Below.
No. It
Well,
says
that-
in remission.
The remission is below the level of schizophrenia.
No,
That I
whatever it
checked
is.
up. That is, in any case, my lord.
No. What steps did you take thereafter?
No, my lord, what steps did he has no schizophrenia. But I'll tell your lordship, my lord, he filed a certificate before the authority say in
No,
2009.
those things we have seen.
There's
Because in the
nothing.
medical board
And
report,
this medical board, my lord,
medical board says that for the last around 2-3 years, he's not taking medicine.
no,
Intermittently,
that is what he said, because
that's the opinion of the medical
that's
board.
not.
He has not been taking medicines regularly. And from 2 years, infrequently he's taking, that's the word used. But he has brought on record a medical certificate of Dr. Ghosh, wherein he says that he's regularly taking medicine. Have you seen that?
No, my lord, after.
You come
this
to
is
page 16.
16 of the writ petition.
No, of the affidavit, additional affidavit filed.
My lord, these certificates.
You come to page,
After,
no, I got it. That's we wanted to know. Come to the affidavit of 31/1/2018,
Okay,
page
page-
25.
Page 16, your lordship is saying. No,
Page 25. That's the medical board opinion.
27 is the medical report. 27.
No, come to page 25.
25, my lord,
Investigation, just opposite to the word investigation, there is a line, box type line, and then continued regular medication till 2009. Then irregularly, 2-3 days in a month, right?
Mhm.
Last intake, 2 years back. Do you get it?
till 2009.
Just below 4/2/2007 date,
4 days last intake.
2 years back. That is the medicine.
Above, this is
You
This
say
is a sign-
occasional alcohol use plus,
No delusion, matter down below, Your Lordship will
I'm
say-
not on that, I'm not on that. Just read those words. Continued regular medication till 2009, then irregularly, 2-3 days in a month. Last intake 2 years back. So this board is of, this board was considered in 2017, right?
What is, how this is relevant?
You come,
And last certificate, Your Lordship will see.
I got it.
It says schizophrenia in remission means there is no schizophrenia. Your Lordship will see the meaning of it. I've checked up.
You come to now. Now, these things, I think you would have to.
Schizophrenia
you
are
have to-
below level needed for schizophrenia. This is what the
You
meaning
come to
says.
page 13A of that affidavit.
30A
A,
of this.
13A.
13A.
So we have a medical board opinion.
My lord,
Wherein-
this,
Mr. Roy,
I
Mr. Roy,
considered
Mr.
for
Roy.
a different purpose. 13A.
Mr. Roy, I'm not against you. I'm not against
I
you.
understand, my lord.
This is something which I require a clarification.
13A. 13.
This is some certificate by Dr. Ghosh, right?
That's right, my lord.
This is to certify so and so is under my treatment since 23/4/2008 due to his psychiatric illness, schizophrenia. He was on medication and still he is advised to continue medication and check up regularly. So this certificate is of 2013, wherein the medical board opinion is that after 2009, he is not taking any medication. You
Okay.
get my point?
Lordship.
Madam,
Lordship.
cover this. When your senior argues, ask him to address this court on this issue also. When? Second,
Monday.
Tuesday. List this matter again
Tuesday.
on 2/4/2020.
Much obliged.
Mr. Just have a look,
I understand.
because that's the only point she has. He has.
Yes, he has made it. After 5 years, he filed a petition. After 5 years.
Yeah.
Take cases. Oh? Then let it be Wednesday, my lord. Can it be on
Thursday? Thursday.
Thursday?
Wednesday, no problem. Wednesday.
Thursday, there are other.
3/4. Wednesday.
But Thursday, I can't. Wednesday.
3/4.
Wednesday. Oh, then Thursday, my lord. Thursday.
Thursday. 4/4.
Oh?
Issue notice, heard Mr. Armuzumdar, Learned Counsel for the petitioner. Also heard Mr. SMT, Miss S. Fukon.
S. Sutia.
S. Sutia, Learned Council, Learned Standing Council, Elementary Education. It's elementary. Yes. Elementary Education Department. So issue notice returnable 4 weeks. Ms. Sutia, Learned Standing Council, Elementary Education accepts notice on behalf of respondent number 1, 2,
5 minutes.
1, 2, 4, and 5. No government advocate today. Ms. R.B. Bora, Learned Government Advocate, appears, accepts notice on behalf of respondent number 3. No formal notice is to be issued, but he can make it. Petitioner to take steps for service of notice upon respondent number 6 by way of registered post with any steps within 3 working days. Also, the matter, the grievance of the petitioner hearing is with regard to the action on the part of the respondent number 6 in not allowing the school managing committee constituted with the petitioner as its president to carry out its functions in the school. Also, the approval of the school managing committee with the petitioner as its president was accorded by the district elementary education officer on 29/1/2024. So, on the last date of listing, that is on 22/3/2024, this court had required Mr. Chisti, the Learned Standing Council, the Learned Standing Council Elementary Education, to receive instruction as to why the body school managing committee with the petitioner as its president is not being allowed to function. Today, Ms. S. Chutia, Learned Standing Council Elementary Education, has placed on record a communication dated 22/3/2024 received by her from the District Elementary Education Officer, Nogam, wherein it has been stated that the managing committee constituted with the petitioner as its president and approval to which was granted on 29/1/2024 by the District Elementary Education Officer is under a process of a review basing on the complaints as raised by the people of the locality.
Last period, the BEO is taking the charge.
So, in view of the issues arising with regard to the functioning of the said body, the BEO Lanka was temporarily allowed to act as the president of the SMC till constitution of a new SMC of the school, while a communication dated 15/3/2024. Full stop. In view of the said position, it is provided that the authorities shall not convene a new board, shall not constitute a new managing committee for the school in question in replacement of the managing committee with the petitioner as its president. Full stop. However, till the next returnable date, the BEO Lanka shall continue to act as the president of the school managing committee. Full stop.
Your Lordship, may I have a copy of this?
They'll give you. A copy of the communication dated 22/3/2024 is kept on record and marked as an X for indication. They'll not constitute a new committee, but you will also not function. Let the BEO function. What right of yours is being hampered? Nothing.
Only that your Lordship, the sub-rule 4 of 13
Nothing other than that midday meal. Nothing.
must
Let the BEO continue.
Lordship, the conducting council is on legs, so kindly pass over the matter for the time being.
I brought the certificate, my lord.
Mr. Chisti, have you got that?
No, my lord, that original service book is with the petition of it is a letter I have received from the headmaster of the particular school of it.
No, we wanted that
That certificate. That is with the petition of it. He has shown me.
You have that certificate, Mr.
Yes, I have. Photocopy हो गया photocopy दीजिए I don't know oh that is दीजिए ये दीजिए
Mr. Sharma,
Yes,
if you can come to page 15,
yes,
right?
my lord.
Page 15. Page 15 of your writ petition.
Yes, my lord.
Now, this 31,364 that is written there,
Yes,
that has been verified by the inspector of schools from some certificate of 24/12/87.
yes.
It cannot be this.
What?
It cannot be this because here the date is 69.
69, yes.
But this inspector of schools, Aminggaon, says that he has verified 64
Yes,
from that same very certificate 24/12/87.
yes,
How? And see, 31,364 is there. Your signature is at serial number 10. Accepting that.
yes, yes. Just a minute.
Page 15. You have the original service book with you.
Yeah, I will given the duplicate.
Huh?
Duplicate.
Just show me the duplicate.
এখন original any এখন photo knowledge of
I think only it is 69 written. 31, 360. It is not 64, I think. It is 69. If you also kindly meticulously see discreetly. I
That's
think-
the first question I asked you, whether it's a case of handwriting.
Yes, I think it is a my lord, juggling of handwriting, my lord. It is 69, I think. So the handwriting is so beautifully written handwriting. You will also be seen the handwriting. It is 69, my lord. No, the certificate is original, my lord. There is no doubt at all. That's why it has lost its ink also. In the service board, it is 69, man. It is not 64 because 64 we write.
Hmm.
No, it is 69. In service book also.
No,
Well-
it is 64.
No, my lord.
Because why?
Yes.
Inside he has written another 4. Same. You have not appeared in the matriculation examination.
No. I didn't appear in the place also.
No, you passed the matriculation HSLC test.
Hello?
You passed the, had not passed.
Not bad. Yeah.
It's difficult because your signature is there. 64.
In which page, my lord?
The first opening page, page 15.
Page 15.
Eruk dirimu. Sound video.
Yes. But in any case, it
This
cannot
is
be
just our
4.
communication,
You will
lord.
also kindly verify again. In the service, it cannot be 4. 4, we will write distinctly, my lord, because
That how can I determine? Because you have signed and they have determined it as 64.
yes.
And your this certificate naturally does not mean. I think you will have to get a declaration on this.
But my lord,
That
the
will require
certificate-
examination.
there is nothing to doubt about the certificate. Certificate is original.
But now, Mr., because of this contradiction,
The contradiction might have committed by the inspector of schools.
okay,
Then you will also
okay,
kindly
we'll
see
find
my-
a way out. We'll
my-
find a
my-
way out.
My handwriting.
We will find a way out, Mister. We'll find a way out. Don't
Yes.
Kamrup, Amingaon,
Yes.
the inspector of schools,
Yes.
Kamrup District Circle, Amingaon, is required to verify the records of the admission register of Bira Datta High School
Yes.
to determine the to determine the date of birth of the petitioner recorded therein. Full stop. The inspector of schools shall personally visit the said school and examine the records and submit his report in the matter. Full stop. The extract of the admission register shall also be taken by the Xerox of a copy of the admission register shall also be taken by the inspector of schools and shall place the same along with his report before this court on the next date fixed. List this matter again on 8/4/2024. Full stop. The petitioner, it is noticed by this court that the petitioner shall, in terms of the date of birth determined, that is 31/3/1964, retire from his services on 31/3/2024. Also, however, the retirement of the petitioner on 31/3/24 shall be subject to further orders that would be passed by this court on 8/4/2024. We'll pass orders.
Because on the first day, my lord, on the motion.
I also have a doubt, mister. It's not that I don't have a doubt, that
Yes.
writing of that 4/9, that's why when the matter came up, first time I told you, are you a victim of handwriting?
Yes.
But we'll
That's
have to
what
confirm
I
that.
was submitting, my lord, that on that first day also, you were also got to remind the matter to inspect schools to determine a pass test order. Now you have-
We will pass that order.
Yes,
Let the inspector give us a report.
yes.
Mr.
Yes,
Chessi, please.
I'll answer.
Or my lord, instead of photocopy, can you not produce the original also?
I'll produce the original also, lordships.
That's up to the,
Yes.
That will
that's
help solve the entire problem.
he's confident.
Because there is something against there.
No, no.
Yeah.
If you
The
are
client
not-
has
no,
given Mr. Sharma the full assurance.
That original admission, attendance register will
Get it?
reveal everything.
We will proceed with that. Don't worry. We will not leave it at that.
Yes.
If it's a new register or an old
The
register,
handwriting is new.
there we can have
Forensic,
have it examined. Don't worry.
Yes,
But
yes.
get it.
Yes, I'll get it.
even this certificate will be sent to forensic, my lord.
Yeah.
19, I need some accommodation, but the instruction I have yet to receive, any day next week, lordship, anything.
If you have to give that, each one.
Just so. That matter.
Yes, yes, lordship.
Mr. We will provide for you a way out.
Yes.
We'll provide a way out. This order of the director,
Yes, your lord.
not in connoissance with the orders passed by this court.
Yes.
This will go.
Yes.
You consider his case.
Yes.
In terms of the
Earlier
order,
orders.
5796.
at page, my lord Justice Jami's order at page 108. Because see, that plea of regularization,
Yes.
he has given up long back. He wants recruitment.
Yes.
It's open to you. We are not saying you give it, but if you're not giving it to him,
Yes.
adduce adequate reasons.
Yes.
This will go.
And this was issued in terms of that particular order only. Only
But,
the
see,
reasons were not.
but that is not the issue that was raised
Yes.
by this court. It's contrary.
Lordship, can you explain it?
We will dispose it of.
Yes.
We will set aside this order, require you to have a relook in the matter in terms of the earlier order. Strictly in terms of the earlier order, liberty is up to you.
Yes.
If you don't give him, assign reasons.
Yes.
If you give him, naturally he will not.
Lord, even my approval for promotion was also sought for, approval for.
And
my-
what happened? What happened to that other person?
He has died.
Miraji
My lord, he has died, my lord.
is gone.
One.
See,
I am also on queue, my lord. If they give appointment, I may survive, my lord.
naturally,
My lord.
but very badly handled. Anyway, let's set them, dispose of.
Obliged.
Move the report. Move the report. Dispose quickly. move the report.
My pleasure, lord.
Take it as radio. Mr. Chisti, you can keep back this.
Yes, yes.
Heard Mr. J. Abedin Learning
My
Council.
lord, may I just show a paper? On the board? My lord, this document, if your lordship kindly
Please
consider,
give it to me.
along with paragraph 8 of my lord's order, my lord.
Paragraph
8. But ultimately, what this person wants, only one day to tell his grandchild or his family members that I have been promoted. Everything is done. Taking the plea of code of conduct, they are not giving it. Otherwise, even the draft is also ready.
Yes, Mr. Who is appealing? Call Mr. Kaushik. Call Mr. Gugoi. K. Gugoi.
Yes. My lord,
We'll
only-
have to have somebody to communicate.
My lord, only one thing, if your lordship remembers that subsequent part your lordship has given on that day, I remember, if the DPC cannot be held, giving that rider of future, not for this
Mr. Gugoi.
director.
This is something not done. We had provided that if the DPC finds him to be suitable, they will send a proposal to the director. They have sent this proposal on 22/2024. 15 days time was given. Why?
Otherwise also lordship has indicated that.
No, forget it.
I have seen it.
Forget it.
Lordship.
At least one day, he gets it. One day he gets it. Ensure that.
If he is not sitting, then also he will get benefit.
No, let him retire
Benefit.
in peace. Because
Benefit.
they have
Otherwise,
complied
only
with that.
yesterday evening I have talked with the
Asking to issue that order by
director,
tonight.
but lordship, some due to the election.
Election code of conduct for promotion, what is that? What is that?
Lordship, it is there also. In the election notification, no promotion and lordship appointment. That is there. That's why that is the reason, lordship. Even one of the cases, we have moved the election commission also, they have negated. One of the contempt cases, honorable division bench says.
Mr.
Lordship.
Abedin, check up the
Lordship.
code of conduct. Whether
Otherwise,
this is also covered. Come back at 2. Tell me.
Otherwise, it's a violation.
it's not a violation.
I'll say it's a violation,
It's
my lord.
not a violation, lordship.
15 days.
Do
clear.
what I,
It's
do
not
what
a
I have
violation,
told you. Do what I have told you.
It's not a
Yes, my
violation.
lord. What
You
time?
want this transmission to be stopped?
No.
No. Then get that.
Even lordship's order never violated, lordship. There is a,
You get that instruction. We'll see. Get that instruction, Mr. Get that instruction means check up that.
lordship.
And Mr. Gugoi, if you find that it can be done, do it.
Wait, please, the lordship.
Hmm.
Challenge to that notification my lord, regarding exit examination. Lordship has fixed similar matters, my lord, on third. May I hand over a copy of the order, my lord, similar implications? That issue regarding my lord, the holding of exit. Holding of exit examination.
Ah.
Concord University. On
That
third.
one, we'll have it on third.
Third. Third. 34.
Respondent same,
Same.
BP Bora or Mr. B Gugoi. Or respondents number
My lord, here 1,
Hmm.
2, 3.
1, 2, and 3.
4 also. 1, 2,
Just
3, 4.
1, 2, 3, 4.
5 you will explain. Okay.
You are for the Assam Pharmacy Council also.
Yes, sir.
Okay. For the respond number CJC appearing for respond number 5. D Gugoi, Learned Standing Council.
One, 2, 3, and 4.
Then who is any other respondent?
No, man.
Only 5.
Only
I am a pharmacy council of India, lordship.
Huh?
I am a pharmacy council of India.
five.
That we have talked about. Mr. Moderator. नहीं माना था अरे ये चीज होगा एक बार रेस्पोंडेंट्स में डालना any one of you on the next date when this is there PCI has an educational regulation get a copy of that latest one and if possible I think executive exam is contemplated there
21st, my lord, of April.
no
There are two regulations of the PCI, my lord. One is of 2020, which prescribes the courses, etc. And one is of 2022, which prescribes for holding of executive
if you can
function.
give a copy before the next day
It is the annex, my lord, in my petition.
yeah where is it okay
The exit examination of B Pharma is the next.
but that's what I'm saying what about B Pharma
B Pharma, there is no exit examination.
it's not
No,
required
it's not. In this case, it is only D Pharma, my lord.
3-4 date same रहेगा 3-4 हाँ नहीं वो नहीं returnable date okay
Petition before your lordship is against the imperial order at page 30, by which her provincialization of service has been cancelled. At page 30.
yes naturally you will work in two schools why should they provincialize you
Now, lordship, if your lordship
Huh?
comes to, if your lordship comes to,
and a letter is also written by the principal
Yes.
at page 29
yes,
that she is working
that is
for
what,
public interest
no,
what
here
is
lordship-
more left
She was working admittedly,
then
but she was also continuously working in the college also.
no
which is the-
we can contemplate that continuous service would mean in one institution not two institutions
And so far the respondent number, private respondent numbers, 5 is concerned. She is also, was also teaching in Mary Grand Academic Institution, lordship.
we will
she
stay
is-
there but
she has
will not stay your cancellation
She has been provincialized, lordship, at page 32. He was
Now-
also working.
Miss Bora how come on the same day so fast
Yes.
you can provincialize without requiring it to be placed before the committees and all or it is already placed before the committee page 32
Yes, Lordship, I have seen Lordship.
On 30th, I was, my provincialization was cancelled, and 14th, this order was issued.
how
Whether earlier place before the committee or not, that is.
Miss R.B. Bora, Lanet, Standing Council BTC shall receive instruction as to shall praise that she be granted 2 weeks time to receive instructions in the matter. Prayer aloud. Also, in the meanwhile, till the next return after full stop. In the meanwhile, till the next returnable date, the operation of the order dated 13/3/2024 bracketed annexus 7 and the order dated 14/3/2024 bracketed annex 8 to the writ petition, dono mein, to the writ petition, shall remain suspended.
Deeply over.
Lordship, I say local instruction, Lordship, on Monday, Lordship.
No, we will wait for 2 weeks. What is the urgency? If you do in this case one day, all cases I want similar. In all cases, instruction within 1 day. Agree? We'll fix it on Monday. Every case you will have to do this. Why only in one case?
Lordship, this is, there is urgency of
What is the urgency? We have said 2 weeks. I think we should give it 4 weeks now. Arek line ligo. The petitioner, in the meanwhile, shall be allowed to continue in her services in terms of the original order of provincialization.
Deeply over.
Anything more?
Lordship, earlier.
The last line to cut it. Anything more? We will record. We will love it. We'll have it on Monday, but Miss Bora will have to get us instruction in every case within 1 day. You can't be selective. List this matter 2 weeks more. List this matter again on 8/4/2024.
Deeply.
Right? 8-4.
My lord, we have already taken discussion.
When?
This is the copy, my lord.
When did you take this steps?
Yesterday, my lord, only the last week, due to some.
In terms of the orders passed on 22/5/2024, requiring the petitioner to take steps in the matter during the course of the day. That is within 22/5/2024. Also, it is seen that the petitioner has not taken, learned counsel for the petitioner has not taken steps in the matter during the course of the day. That is on 22/5/2024. Today, Mr. S. Sharma submits that the steps were taken on 27/3/2024. Accordingly, in terms of the earlier orders, the interim order passed by this court on 25/2022 stands vacated. The registry to proceed with the matter in term and issue the notices to the private respondent hearing to the respondent number 6 and 7 in terms of the order dated 25/2022.
Deeply obliged, my lord.
Can't help it. We gave you time, you did not. We'll have to follow up this.
Yes, deeply.
You take this back, Mr. Sharma. Now, yes, really matter. Yes. Where is Mr. Abedin?
Here, my.
No, he's here, he's here. He's a bit agitated today. Don't worry. Mr. Abedin is slightly agitated. So he'll have to be normalized. I think you can have a smile. There is no problem.
No, my lord, bit agitated because why to take such a sadistic pleasure by an employer after 33 years of service given by one gentleman?
Just remember those days when you were on the other side. Now,
my lord, I can proudly say never did all this.
Right.
My lord, would it be your lordship be pleased to pass over this item, my lord?
Okay, done. We will not take it. Mr. Ghosh, Mr. Abedin seems to be not in the frame of mind. When do you want it?
Only a day to be.
My lord, for that day only.
We'll have it on 3rd, 3/4. On the learned for prayer of the learned council for the parties, this is again on 3/4. Everything will fall in place.
No, my lord, I'm coming back that side. I've got the notification.
Got the notification?
Yes, yes.
Then fine. Get Mr. Goswami also. Gogoi. Huh?
The earlier occasion, my lord.
Okay, fine. Forget the earlier occasion. Now you tell me.
My lord.
When did your father die?
Father died in the year 1999. my lord.
99. What is the responsibility of the, who is appearing for the government here?
I'm appearing.
You are appearing. Now explain, how was his appointment made in 22 when the father had died in 1999? 99. Why was this appointment made in 2022? If that is the policy of the government, we will follow that. We will direct all compassionate appointment. I am recalling all my orders. Just now I am recalling my orders.
He'll be appearing for the government. And for the
No,
department.
no, you are the department. You should know. You forwarded the proposal.
My lord, but the, no, my lord, the government who's going to be.
No, no, you forwarded the proposal.
My lord, he's the forwarding. Compassionate appointment.
Yes, how is the appointment made in 22? When the father died in 1999?
Yes.
Show me. And we are following that, you're this order now. I'm recalling all my orders. This is not done. How can you be selective?
Second thing, at that time of application, he was minor.
We are interfering with this appointment.
Yes,
And we will also not
I'm by
get it.
your lordship.
You're also not getting it.
Yes.
Both gone. Who is appearing for respondent number 9?
Earlier occasion.
You are appearing. Huh? Tell me, how did you get this appointment? Come this way. What is the formula?
My lord, actually, in this case, Mr. Y.S. Manan is appearing, my lord. So, my lord,
He's here.
my lord,
He was supposed to file an affidavit and he'll appear here.
lordship.
We permitted. Okay, at 2 o'clock. Call it. We'll interfere with your brother's appointment. You will be happy. And we will say that you are also not entitled.
That was illegal, my lord.
Both, that's what you have run a right thing in pointing it out before us. But you are also not going to get it. End of the matter. Let that post go to some person on merits. And Mr. Dury,
Yes, your lordship.
find out what is the principle behind this giving this appointment, compassion appointment. A man died in 99, appointing in 22. Get that instruction from your deputy commissioner.
Yes, your lordship.
And also ask him
Yes, your lordship.
as to whether the qualifications that have been acquired after the application can also be considered. Get an instruction, 2 o'clock.
Yes.
2023. Yes,
Yeah, but then last occasion also, my lord.
Mr. Nayak was supposed to.
Lordship, in this case, on last date, lordship, the direction was issued to file my affidavit, lordship. Instruction is already there. Affidavit has been sent for vetting law.
Last occasion also, my lord, took same claim, my lord.
No, last occasion differently. Last occasion, this was not differently. Last occasion was he has received the instruction. He will file the affidavit.
Yes, ma'am.
So today, it's not that he has prepared the affidavit, it's sent for vetting. So how can it be the same plea?
Then next day will be, my lord, it has not been signed.
No, Mr.
my lord,
Next
last-
day it will come. When, Mr. Nayak?
Last chance, my lord.
When?
Again and again, my lord.
When?
Lordship will take up after verification. In the meantime, it will be.
We'll have it on 19th.
Lordship.
Mr. Nayak submits
In
that
next-
the
next
affidavit
week, Lordship.
in the matter would be filed within a week. Full stop. List this matter on, again on 19/4/2024.
Lordship may take up this matter on in the 4th week, Lordship.
22nd. 22nd.
Be
Full stop.
20
In the
24.
event, the affidavit of the respondent BTC is not filed in the matter, in the meanwhile, no further opportunity for filing such affidavit would be permitted.
On 23rd.
23rd, okay, 23rd.
23rd.
No further opportunity for filing the affidavit would be permitted, and the matter would be disposed of based on the materials available on the court.
That is a lot. My lord, only thing possibly in the present form, the petition is not maintainable because the.
No, first, you were supposed to provide the records.
Yes, that is there.
Yeah.
But what I'm saying that DSC has already passed the order, my lord.
If you lordship's order, 12-1 lordship. 12-1 may kindly be seen.
Dada, lordship.
Okay. You are appearing for Mr. College.
Yes.
You?
I'm the in charge principal.
Huh?
In charge principal now.
Mr. Anwarul
Yes.
Islam Khan.
Yes.
Who is appearing for the government? Mr. Gogoi, you are appearing. College. No, just give us a idea. Come to page 17 of the writ petition.
Service provincialized one.
Lordship, lordship,
Serial number 1, Borpeta Bongaigaon College.
lordship,
Manikali, principal, yet to be provincialized.
Yes.
What is this?
lordship,
How can a person, now he's an outsider.
lordship,
How can he be made, how was he made a principal?
lordship. It's a wrong lordship. It cannot be lordship. His name should not be
They
figured.
have my lord own my lord notification, my lord.
That's,
And it was,
that's in a provincialized college.
yes, it
How
was,
can an unprovincialized man
That cannot be lordship.
hold? Just show me, Mr. Ali. Show me a thing on that. We'll interfere.
my lord, the notification they have, my lord, referred, my lord.
No.
On the basis of this notification, the government has decided, my lord, when the, my lord, particular submitted, my lord,
How can they do that in violation of the, once this is done, they're coming under the 2005 Act.
yes.
Once it is provincialized, they'll come under the 2005 Act and the rules 2010. How can this be done? Okay, what is your grievance?
My grievance, my lord, he was arrested, my lord. He was arrested on 6/11, released on bail on 8.
Released on bail thereafter.
18/11. Thereafter, my lord, I am not allowed to
Work.
work. Neither I have been placed under suspension, no action. I filed representation.
Now they have appointed somebody else. Department of Principal in charge. Okay, fine. Your services have still not been provincialized.
No. It was under my lord observation because some query was made.
Whatever it is, but it's still not
Lost.
provincialized. Okay,
Lost.
fine. Heard Mr. R. Ali, Learned Counsel for the
Only
petition.
4 persons are provincialized, lordship there.
Heard Mr. R. Ali, Learned Counsel for the petition. Also heard Mr. K. Gugui, Learned Standing Counsel, Higher Education Department, appearing for the respond number 1 and 2. Also heard Mr. J. Abedin, Learned Counsel, appearing for the respondent number 3. And Mr. H.I. Huh? 4. So and so for respond number 4. Also, the grievance raised by the petitioner in the present proceedings is with regard to the inaction on the part of the authorities of the college in allowing him to continue to hold the post of principal of the college in terms of the order dated 28/12/2021 issued by the Director of Higher Education Assam after he was released on bail in the criminal case in which he was implicated. Also, the petitioner on his release on bail in the criminal case involved, had approached the governing body as well as governing body of the college as well as the Director of Higher Education to take immediate steps to allow him to continue in his service as continue to hold the post of principal of the college in question. The same not having evoked a positive response, the present proceedings have been instituted. Full stop. On perusal of the order dated 28/12/2021, it is seen that the petitioner was allowed to function, allowed to hold the post of principal of the college. However, the services of the petitioner was not provincialized as on that day, while the incumbents, while the other serving teachers or serving professors or serving teachers of the college, while the service of serving teachers of the college were so provincialized. It is not discernible as to why a person whose services have not been provincialized was allowed to hold the charge of the post of principal in a provincialized college. Also, be that as it may, today, at the time of hearing of the matter, Mr. Abedin, Learned Counsel, appearing for the respondent number 3, has produced before this court an order dated 12/2/2024 issued by the Director of Higher Education Assam, by which the director in terms of the resolution of the governing body taken in its meeting dated 10/11/2022 has appointed the respondent number 4 as the principal in charge of the college for a period of 3 months with effect from 1/2/2024, in addition to his normal duties. Also, it is stated at the bar that the services of the respondent number 4 was provincialized. Accordingly, the order dated 12/2/2024 as passed, having allowed a provincialized employee to hold the charge of the principal of the college, this court finds that the order dated 28/12/2021 issued in favor of the petitioner now stands superseded. Also, accordingly, the writ petition is held to be without any merit and the same stands dismissed. Also, however, it is needless to point out that in the event the services of the petitioner are provincialized in terms of the provisions of the Act of 2017, and the petitioner is otherwise qualified to hold the post of principal of the college, and there is no impediment, a legal impediment in this connection, the petitioner shall be at liberty to make appropriate application in this connection before the competent authority for allowing him to hold the charge of the post of principal. Right?
Regarding, my lord, remuneration, my lord.
Remuneration, you are not going to get anything because that was just the in charge arrangement, 49C. You're not going to get.
But in charge, my lord, on the academic side, because
Academic side, see, you are a provincialized employee. You are not a provincialized employee. How can we direct for a payment of a salary to you?
no, salary from the college, my lord, because remuneration was given by the college.
That you go and make your, for that period. We are saying nothing. We have kept it blank. We have only provided if you are free from everything and you are senior most, you can make your claim. That's all. They have not filed, Mr. Guy, Ms. Gan, have you got the records?
Yes, my lord, I'm taking my lord, but that is in out there. They are outside. They may appear in the court from the outside.
Mr. Das.
Yes, ma'am.
One by one.
Yes. I'll take your lordship with each and every detail of the allegations in the charge.
But this will take some time, I suppose.
Will take some time.
We'll finish off the list, then come back.
Fine, absolutely.
We'll finish off the list and come back.
My lord, after 2:30, but I have to go to take my son from the board examination is going on. That's 2:30, my lord. I'll come back at 2:30, my lord. If possible. 2:15 or 2:30, I'll reach by.
Need not have take that much of a rush. There is no rush here.
Yeah.
We can always wait for a day.
Yeah.
Would it be inconvenient on first for you? First or second?
Second, my lord, because the first
Second.
exam is also on fast, my lord.
First,
That's why,
second.
Second, my lord.
Second, we will have it.
Yeah.
We will have it immediately after the top of the list items.
Top of the list, my lord.
After the top of the list
Yes.
item. Mr. Das,
Second, my lord, there is
Fourth.
another matter.
Fourth. Third also, no problem.
Third, I don't have problem after one, my lord.
Third also, no problem.
Third,
After the top of the list matter, we will take it up.
my lord.
But give me a small summary
Fine.
and finish it off within 10-20 minutes. You give your point wise
Yes.
thing
Yes.
and we'll finish it up.
My lord, I may be allowed to file the affidavit in.
No need.
No need, it's.
Affidavit will take time. You have the records?
Yes.
Department proceeding, we only have to cross verify. That's all.
আজি নোৱাৰিবি নেকি?
নালাগে।
আজি নকৰে।
আজি পাৰিম, দুটা পুনৰ আহি পাম মই।
Let her not have.
Fine,
We'll have it on 4th. You
Fine.
do it.
At 2:15, I'll reach.
Whatever is to be done, we have already protected you to a certain extent. Other part also, if
They
we,
are taking pleasure, they have already retired me and they are taking that pleasure.
let them, if
Fine,
you
sir,
succeed,
no issue.
if you succeed,
Yes, ma'am.
then the pleasure might shift as a pain to somebody else also.
True. And I have also.
And
without
be very
fair-
careful, Mr. Gan.
Yes,
your records be very meticulous because we find things are not what they are. We may have to proceed against your authorities also. Be very careful. Mr. Das, give me that point-wise thing.
List of dates wise and.
Not list of dates, point.
wise. Yes, yes.
These are the paragraph. Point,
Yes.
these are the paragraph.
Fine, fine, fine. Third, my lord.
I think you have gone a little bit overboard, subject to what your records would say. And be very careful. You still have time.
Yes, madam.
If you want to take remedial measures, you can take remedial measures. We permit you. We will not hold it against you.
Fine.
When?
Third. Highly approved.
List this matter again on 3/4/2024. It will file to Mulla for further hearing. We understanding is after the top of the list matters, we will take up your matter.
Fine.
Yes.
Thereafter, we'll go to the list
Fine.
and be precise as far as possible.
Yes. Deeply.
File to Mukhali. It will be, yeah, I sleep. File to Mukhali.
Right, please, your lordship. Lordship, in this case, two posts have been provincialized. Language is yet to be provincialized. Only one social science and science provincialized. Page 59, by this order. Even my lord, your lordship kindly see.
Yes, Mr. Fukan. You were supposed to give us instructions.
Send the instructions there, madam.
I said the instruction.
Technically, my lord, 3/111, 3 teachers has to be there. What he's saying is correct, but my lord, in the order, it is, I mean.
No, no.
Even my lord, impugned order passed before the High Court's order, my lord. Page 62, my lord. High Court order 6/5/22. Impugned order passed on 25th April 20, prior to the High Court's order. That format order, my lord. Page 67. Same ground impugned order dated 25th April 22. Whereas Honorable High Court set aside the order on 6/5/20.
No, nothing doing. Mr. Fukan,
My lord,
you come to page 60.
my lord. In view of the decision, my lord.
Because there reveals that DCS so-and-so recommended 4 numbers. Read it once.
In view of the above, it reveals that as the DSC Thukuri recommended 4 numbers of teachers against so-and-so, out of which 2 language teachers were recommended, namely so-and-so and so-and-so, Asuma Ahmed. But as per the plus 3/111, the school is entitled 3 teachers for provincialization
Right?
of service based on enrollment of the school. As such, SNC recommend 3 teachers, language, science, and social science.
In between, you will find 3 pages. Come to
Right.
page 62.
60, well.
62.
Well.
This is an order of this court. Right? By this, the earlier order was interfered with, 710, right?
Well.
And it has put in some observations.
Well.
Huh? Now you come to your director's order at page 66. Forget the first part, come to page 67. What is this? You have reiterated the same thing.
Same thing, man.
Wait,
Well, error method on the part of.
wait.
Same order has been passed. It's apparent, my lord.
We'll interfere with this. We'll ask you to redo the matter in strictly in terms of the earlier orders. Of
Earlier
this
order.
court, right?
My lord.
A specific direction may be issued, my lord, since post is there, my lord. Language is yet to be provincialized.
Who are the teachers now recommended? Monafali.
My lord,
Monafali.
Monapalli and Krishna Chandra Roy.
Roy is for what?
Roy is Krishna Chandra Roy for social science.
Social science.
And Monapalli science teacher. They have been provincialized,
science.
2 provincialized. Now language is yet to be provincialized.
Okay, we'll pass orders at 2.
Well,
2 hours at the
My lord, can it be up to 10?
You come back, tell it.
210, my lord.
So you tell it, we'll call it.
I am.
Maybe, this is, my lord, the violation of the order dated 39/2019, my lord. My lord, respondent number 2, my lord, has not yet been appeared, my lord. We have taken steps, my lord. Director of pension, my lord.
The steps on the notice, notice was issued to the respondent number 2 on 12/3/2020 only. List this matter after 4 weeks on a date to be fixed by the registry. On the next day, a note with regard to service of notice upon respondent number 2. Status of with regard to service of notice upon respondent number 2 shall be made by the registry.
Obliged.
This court wide order dated
Yeah, but the matter has already been admitted, rule issue.
That's what I'm saying.
And my lord, the affidavit has been exchanged. Only my lord, the lordship may fix.
This court wide order dated 27/1/2023 had admitted the matter for hearing. Accordingly, registry is directed to
My
list
lord,
this matter for
If it's
hearing.
after view vacation, my lord. there is some
After 3 weeks on a date to be fixed by the registry.
Or before view vacation, lord. if
After-
convenient.
After 3 weeks on a date to be fixed by the registry. We'll come up for hearing.
My lord, my name may be recorded, my lord.
Mr. B.J. Ghosh, learned counsel, appears for the petitioner, and Mr. I. Alam, learned counsel, appear representing the NCTE. After the view vacation.
Be disposed of, my lord.
I know, but we'll
Because
have it.
my lord, the grounds they have rejected these are foreign, I am not aware of this, my lord. Ground of rejection or something, ground of.
Once
appeal or
the
something
court has
rejected
admitted,
some other
once the
grounds.
court has admitted.
Yes. My lord, can you be date maybe otherwise, I'm not.
No, it's okay.
Lordship, so
3 weeks, Diana.
please.
23/4/2024.
Obliged, sir.
Due.
May please, your lordship.
You have not taken steps.
We have taken steps, lord.
Where is the affidavit, Dusty?
Affidavit today it has been filed, lordship.
Huh?
Today it has been filed.
It has been. Their respondents have not appeared.
No, they declined to accept the notice. Lordship may give a direction in the main appeal to take steps by registered post with AD. I'll take steps today itself.
The petitioner submits that the affidavit for issue of notice, for service of notice upon the respondent number 5 has been filed by way of Dusty mode has been filed today. Also, however, it is pointed out that the respondents have refused to take copy of receive the notice also. Its notice is already there over here. Also,
No.
in view of the above position, the petitioner is permitted to take service to issue a service of notice upon the respondent number 4 by way of registered post with AD. Steps within 2 working days. Interim order passed earlier to continue till the next date of listing. List this matter again on 29/4/2024.
Always.
Oh, no, I had to do. I had to ask.
The order will be in the IL. We have to take steps both in the appeal as well as in the IL.
Wait, one second. ये जो order दिया ना, इसको आप आए नहीं ना, हाँ, उसके बाद main appeal में लिखना, the petitioner is permitted to take steps for service of notice upon the respondent number
1 and 2.
1 and 2 by way of registered post with AD, steps within 2 days.
Yes.
Also, the matter be listed again on 29/4/2024 along with I bracketed C number 670 of 2024.
My lord, I am for the petitioner, my lord.
Just a moment, Mr.
Yes. I pay for short time.
Actually, you're entitled. You served him only on the other day.
My lord, it is also already one
Huh?
month over, my lord.
Huh?
It was served on 7/2/24.
1 month, but it came to us all today only. He's entitled. How many time? How much? 1 week?
Short time.
Short days, that's short days.
List this matter again on 8/4/2024. In the meanwhile, the opposite party number 1
Yes, sir.
oblique writ petitioner is permitted to bring on record the objections. Will bring on record his objections in the matter.
Right.
Full stop. 8/4.
8/4.
You
All
fine.
right.
Mr. Pine will have it.
Yes.
Let him bring it on record. Yes, who is appearing? Mr. Borak. Yes, Mr. Majumdar.
Both Bora and Vedanta Kosip lordship, I'm very sorry, they are both out of session lordship in this case. May taken out.
No, this was, we required instruction whether what has happened after the, Mr. Gogoi has come and told us that the
Finance has already.
has already approved.
Yes.
Now, what was done thereafter? We just want to know. You have your instructions, we'll have it at after the second half
My lord,
or on Monday.
Monday lordship.
Monday.
Monday.
Tuesday.
Tuesday, I will definitely have it. Tuesday.
Tuesday.
my lord,
List is,
with regard to the item number 38, my lord, contempt 96, complied with, my lord.
oh, complied with. Only
Now-
39 is left now.
39.
36 likhna to. 96. 96 complied with.
96 complied.
Contact
Okay,
case number
Sally.
96 of 2022. Mr. A.K. Hussain, learned counsel for the petitioner submits that the respondents have complied with the directions passed by this court while order dated 17/12/2019 in WPC number 2206/2015. Accordingly, the writ contempt petition stands closed. इसको segregate कर दो अभी नया order मारिए 39 में ये तो dispose हो गया 96 to 39 में order होगा on the prayer of Mr. SMT Sisti list this matter again on 2/4/2024 मेरी में कम करना ये जो order है इसका एक कॉपी और इसका एक ये दोनों ये फाइल जरूर से केस में
मतलब 2nd of April.
second of it.
In earlier case, my name may can be recorded.
Mr. SMT Sisti,
For the
learned
Department of.
counsel representing the respondents is present. आगे वाला केस में SMT Sisti, learned item number 38 में contempt case 96 अभी जो dispose किया SMT Sisti, learned counsel representing the respondents is present. Okay.
Oblige. High level.
So it was the last order.
Yes. What is your instruction, Ms. Boran?
There is a goof up, madam. There is a goof up, lordship.
I knew.
Fifth. Fourth and fifth paragraph.
Mr. Majumdar, R. Majumdar, learned counsel representing the respondents have has submitted on instruction that the notices inadvertently notices for hearing. Notices for the hearing fixed on 8/3/2024 inadvertently was not forwarded to the petitioners. And accordingly, the order dated 21/3/2024 passed by the Secretary to the Government of Assam Department of School Education in pursuance to directions passed by this court in WPC number 3002/2022 is being withdrawn. Accordingly, a fresh date of hearing is fixed on 9/4/2024. Full stop. Whereas the learned counsel for the petitioner appearing in the matter is to take notice of the said date and intimate the same to the petitioners. Full stop. The respondents also will take all possible, will invariably intimate each of the petitioners separately about the fixation of 9/4/2024 as the next date of hearing before the departmental authorities. Full stop. A copy of the communication dated 28/3/2024 as furnished by Mr. R. Mujumdar is kept on the file and marked as Y for the purpose of identification. List this matter again on 29/4/2024, on which date the Mr. Mujumdar shall furnish the decision that is to be arrived, that would be arrived at in the matter after the hearing on 9/4/2024.
My lord, could it be sometime on May, my lord? I may not be here on the last week.
May when?
First week of May, I'm back. My lord.
May 3rd, 3/5.
My lord, one more indulgence, my lord. Item number 9 today's list, lordship has fixed it on Thursday 4th. I am out of station. Mr. Gogoi is here, my lord. We had a discussion. But any other day, 4th, I am not here. 1st and 4th, I am not here.
Oh, that TB.
Well,
TB matter.
Yes, TB matter.
When?
Any time, except the 4th. I'm not here on the 4th.
কোনে বা লৈছিল তো? Huh? Because it's not কেতিয়া fix করা আছে আমার?
4th.
2/4.
No, 2/4 is anything. No, 4/4 is not 2/4 is. 2/4.
2/4.
Second I'm here.
2/4.
Second no.
No, ঠিক আছে. Yes.
Okay, in respect to item number 30.
Yes. You have something to say?
No.
The 13 matter, oil matter, promotion policy. My only submission is that, my lord, in my appointment order, there is no mention that I was appointed against the additional post, my lord. So that is
Need
why.
not be.
that was not
You have not disputed that. That normally is not mentioned, Mr.
Yes, please.
Deka, that's normally not mentioned. But now that they have brought that on record, we'll have to take it on its face value because we can't say that they are making a wrong statement.
Yes, sir.
So that's the matter.
When my promotion was denied from 1st of January of that year, I made an application before them.
They still did not tell you that.
Yes. They in their response, they informed me that since I was appointed against the additional post.
Oh, then that
Yes, after
notice.
that- Thereafter, my lord, I filed this petition.
Petitioner number 2 is never already deleted, lordship.
Huh?
Petitioner in respect of petitioner.
Petition number 2 is gone. It's only with regard to petition number
Petition
1.
one only, my lord.
Okay.
Wait, please, your lordship.
In the other matter, your lordship has fixed my matter at 2.
Hmm.
2, I have some difficulty. Can it be taken up, my learned?
Yes,
colleague?
now it's.
In this matter.
You have not filed any affidavit.
Sorry,
Now,
your
one
lordship,
thing,
it was
Mr.
supposed to have been filed.
Now forget it. Now tell me one thing. The employee died in 1999.
Lordship.
How can this compassion carry on till 2024, 22?
See, our part, basically, we have filed our application within the period of 1 month. So we filed it within the period.
Now, what do you say
Now, what
about
has
the
happened?
objection of your brother?
No, his objection was basically that I have been given by fraud. He should have got it. Obviously, let us take it this way. There were two applications filed. He has also filed, I have also filed. Both are brothers. Now the question arises, the government will decide who is the person whom they will give. Now, they have taken some time because it has went to the district committee, then to the.
What is your date of birth, Mr.?
That was the issue they have taken.
No, what
But
was the date of birth?
date of birth was, as per the record. Just one moment.
Yes, 26, madam. Regalia certificate.
On the page?
26.
So you were 16 years at.
It was shown as 16 years at that point of time. And the person concerned was shown as 19 years.
Now, Mr. You have been appointed as a
It is.
assistant teacher.
Yes.
He's been appointed as Mr. Padgiri as
Assistant teacher.
assistant teacher.
teacher.
So when you applied, you did not have this qualification. In 2000, when this application was made,
Lordship.
you didn't have this qualification. How come the government has come to know about your qualification? Because the only application I find they have considered
Yes.
is your application of 2000. How come this other part they came to know?
Basically, what I would like to say, it's the government who has decided
Fine,
whether
we'll
I'm
ask the
entitled to what.
Yes, Mr. Dury, what is
Basically,
it?
that part.
What is it?
If they would have rejected me, it
No,
would have been yes.
they have not, but there is a challenge. Compassionate appointment after 22 years,
That is also true, your lordship. Now also they are coming.
24 years. And that too, basing on materials which are not there in the original application. Yes, Mr.
Yes, your lordship.
Hmm.
Lordship, on perusal of the petition, your lordship.
We don't want
first,
you to peruse. We want you to have the instruction. Why they did this?
Instruction right now, your lordship, I have not been able to procure. I tried to contact the concerned.
Tej Pratal Bhushal, ACS, Deputy Commissioner, Borpeta. Have your instructions?
Now it is Ayush Garg.
Whoever it
Yes,
is,
sir.
have your instruction, how this one. And Mr. Mana, we would like you to assist us on one issue.
Yes.
Whether this qualification that is being acquired subsequently can also be considered by the.
That is issue because most probably what has happened, maybe he has subsequently submitted some documents which is taken considered by the government. Maybe when the.
No, but there has to be a law. Just find it out. Not for this. It's for the understanding of the court. Find that out.
Lordship,
We'll have it on 4th.
Lordship, normally practice followed, just subject to your lordship's permission, your lordship. On the date on which he is to be appointed or what, that person's. So that qualification is taken into account.
That is taken into
That
account.
is there. The fact is that now since the material is the NOC and all the allegations with regard to that also, and definitely he was 16 years and his brother was 19 years. Definitely he's also ought to have considered, and your lordship's deliberation that after 1999 and in 2022, your lordship, so all those.
That will be on 4th.
Fourth.
At that time, I'll also get the instructions.
You have it. And we want it. On what law you have considered his case after 22 years. And get a written instruction from the deputy.
Yes.
On the next date fix, Mr. B. Dury, Learned Counsel, appearing for the respondent number 6. Shall receive written instructions from the authority as to the law, as to the provisions of law under which the case of the respondent number 9 was considered for appointment on compassionate grounds after around
21 years.
21 years from the death of the deceased employee, that is the father of the respondent number 9.
23 years. 1990. 23 years.
23 years.
Lordship, may I pray your lordship that date, can your lordship just defer it for someone more days? For
8.
Oblige your lordship.
Get that instruction.
Yes, yes.
बाकी सब दूता उधर से. Yo.
All right.
Next matter, Mr. Abhinay. Next, we'll take. Yes.
May it please, Your Lordship. I'm on a very narrow ground, as the Lordship had rightly pointed out. In fact, the entire exercise of having the matter being remanded to the authorities and for the authorities to take a call on our pleadings has already been done. Your Lordship will kindly come to page 78. So the state has already made their intentions clear that under the 2011 Act, there is no concept of any consequential seniority. Now, although the Act has been repealed, Your Lordship, under the 2011 Act, I just like to point out one aspect for Your Lordship. Assam, 650, no?
Yes.
Yes.
Which provision?
6, Your Lordship, under section 4 of the 2011 Act.
Page.
It's in this book, it's 653, Your Lordship.
653. Okay.
Yes.
Section 4. Yeah.
Section 4.
Huh.
Now, this is under challenge, and pursuant to this and 10(4), the Act was repealed. But the services of the employees of all eligible venture education.
You're reading?
Four,
Okay, 4.
The services of the employees of all eligible venture educational institutions under section 3 shall be deemed to have been provincialized on the date of coming on the force of this Act. And they shall become employees of the state government with effect from date, provided that such institutions have completed at least 7 years of imparting education on the date of affiliation.
Okay, then.
Now this was what has been relied by the authorities. That since the institutions were already in existence in 1991 and thereafter and there before, the venture education institutions will come under the purview of the 2011 Act. However, the Act does not provide for any consequential benefits. Now, if your Lordship allows this petition, subject to Lordship's interpretation, if your Lordship allows this petition in its entirety, then 2 orders of provincialization cannot stand for one set of petitions. Then one has to go. And by that logic, your Lordship, maybe the benefit of provincialization of 91 would stand and the current provincialization goes. But the matter has to be examined.
But where is your provincialization order of 1991?
The order that was the Act which was done by the government. And there were many venture institutions. Yes.
You were not covered under that Act. There was no order in your favor.
Yes, because the Act was not questioned there. Yes.
Provincializing your services under the 91 Act.
Yes.
There is no order.
There is no order.
The only order of the government provincializing your services is under 2011.
Yes.
So what we do is, subject to what you say, we will set aside the 2011. And then ask you to go to the government and pray that we give us 91. If the government gives you, take it.
But that exercise has already been done before, Your Lordship.
Then that is the end of the matter. We will uphold it.
No, then Your Lordship will.
What relief can we give you?
No, the relief that Your Lordship will give us is that Your Lordship will assess our claims.
We will not.
We
will not.
On mere parity.
We will not touch that.
On basis of parity, Your Lordship.
No, we will not touch that.
This goes.
We'll do one thing. We can do one thing.
Yes.
We can ask, because the government says that as you are in provincialized in 2011 Act, so we can't go beyond 2011. We will interfere with that. We will say all benefits that you have got, take it back. Now you make an application that we should be covered by under 91 Act.
Now, if
that is under law permissible, they'll give it to you.
Then if you're covered under 91, then the 13 Act will go, because we cannot be left stranded.
No. You can't have two things together.
We will not have 2 things.
If you want to have your consideration under 91, law permitting, they'll consider.
Yes.
But you will not get it under 11.
Absolutely not. I'm full agreement with the Lordship.
Then we'll pass that on.
No, but your Lordship will kindly just pray. I'll just make one small submission. If my 91 claim goes
It's gone, you are gone forever.
That
You
is-
will not
that-
get back 2011.
That is
You will
is
not
the
get back
difficulty
that.
I
We
have.
will make it very clear.
That is the difficulty that I
Then-
have, your lordship. Then
That-
now 2013, your lordship, was a result
This
of
cannot be done.
your lordship. 2013 was a result of inaction of the government for 2 decades.
Be that as it
For
may.
2 decades, your lordship.
Be that as it may, you were also sitting for 2 decades.
No, absolutely not. We are part of the. You're part
Whatever
of-
it is, you should not have accepted this.
But your lordship, the bargaining, we are the far end of the stick, your lordship.
Then bargaining, we are giving you the power now.
No,
We are
no.
interfering.
But your
We are
lordship,
taking the wins out of the sail of the government.
but
Because now they will not be able to take that plea.
no, absolutely not. But
Then-
then what happens is, if for reason for attributable to the government or the petitioners, if there is something which is not that, I have come with clean hands, absolute clean hands, your lordship. My prayer is that something which I had wanted or which I had entitled.
Be
to-
satisfied with what you have got. There is no right.
Then I'll pray a far-fetched prayer for your lordship. Your lordship will kindly satisfy. I tried. I'll prepare and scale up on this matter, your lordship, and I'll try and satisfy this on one last occasion.
You want an adjournment, take it. When do you want it?
I'll leave it next week on Friday. Next Friday. Next Friday.
Next, on the prayer of Mr. M. Sharma, list this matter again on 5/4. That anytime,
No, but
anytime.
no.
If you want to scale up, anytime, no problem.
Don't want to fail the petitioner
But
because
the offer is, we will interfere with 2011 if you want. Leave you at the mercy of the government for
Yeah.
91. If the government does not give you 91, they are not also, they will also not call them. Because now the 2011 Act is not there.
Yes.
You'll not get 2011.
But again, my consideration, subject to my satisfying this court on the next day, their consideration, my consideration on 91 has to be on grounds which is similar to the other candidates. If I do not fulfill, then that means I
Because
would
Mr.
come-
Sharma, once we allow your prayer,
Yes,
the government will be saddled with thousands of such cases
Yes, sir.
of 91.
Yes.
1. 2, moment we allow your prayer, persons provincialized under 2017 Act, the next writ petition would be, because this has been given effect from 91. We are also there,
Yes.
91, 92, or they'll say, give it to us under 2011 when it was surviving.
but maybe the fence sitting aspect will also come in. I just, again, that is my, I'll try and scale up, your lordship. I'll satisfy this court.
Hey, item number here, it's 30. 33. Mr. Abedin, yours was 33. Yes. Mr. Das, what is the position? No appointments or promotion in government, public and shall be made during this period without prior clearance of the commission.
No appointment.
No appointment or promotion.
Trash, my lord.
No appointments or promotions in government or public undertaking shall be made during this period without prior clearance of the commission.
Well, actually, while going through, we tried to find a judgment. And ultimately, we found a judgment from the apex court. We make it clear that the election code of conduct will not be treated as an impediment to comply with judgment of this honorable court, and the promotions may be accordingly made.
Give me the
Wherever-
citation.
Yes, my lord. My lord, citation is BK Pavitra. Pavitra.
BK Pavitra.
Yes, my lord. My lord, versus the Union of India. BK Pavitra ETC versus Union of India. And the delivery of the judgment is, my lord, 25/4/2018. My lord, paragraph number 2.
Mr. Das,
Yes, my lord.
you've seen that judgment? Go through it.
I'll go.
Ask the authorities. There is an order. They have already, the college has already submitted its
Yes,
thing. We wanted it. Pass orders by 2nd of. We will take this matter at 3 o'clock.
I'll go through it.
You go through it. We will take this matter at 3 o'clock. The direction was that the college will consider. College has considered. Now, the only impediment they say is that election commission, that judgment you take note of.
Yes.
Ask your authority.
Only thing is that my lord's 15 days is prior to the code of conduct is over.
Be that as it. Have it. 2 o'clock. Mr. Gogoi is also here. Explain it to him. We'll come back at 2. Who is opposing you? Get someone else. Nobody. Just wait for some time. Wait for some time. Yep. Comment of Bahok, Kabisa. Comment of Bahok. So, item given. It also. Yes. Puna is. I do. Yes. Huh? I didn't get you. কি কৈ আছে শুনিব পাম on the way. Okay. Who is your senior? Who is your senior? Huh? Okay, we'll take it. We'll call up once more. If he's here, he's here. Otherwise, we'll proceed. Mr. Nanda, wait for some time. Next. Yes, argue. You are appearing for? Counsel, you are appearing for? Sound क्यों है मैं? Sound na, madam.
Lordship, Lordship, I'm appearing for the senior standing counsel for PNRD department.
PNRD, okay. Yes, start.
Click the button.
Yes.
Yes, your lordship.
What is your case?
Your lordship, the case is about regularization of work,
Okay.
your lordship.
Okay, then
Uh,
go ahead.
Your lordship, similarly situated candidates were given regularization jobs, like 101 candidates, your lordship. And I'm not regularized, your lordship, and I'm physically handicapped. And I was physically handicapped during working hours, your lordship. And the division and the honorable division bench judgment is not relevant to this case, your lordship, as the honorable division bench talks about tax collector, but this is about Gao Panchayat secretary, your lordship. And I'm physically handicapped, and I'm given the certificate of physically handicapped certificate, and I'm not regularized. And my salary is, I'm not getting the salary, your lordship.
Okay. Okay, anything more? What do you want?
I want the intervention of this honorable court in this matter, your lordship.
Okay, good. See how beautifully you have placed it. Short and sweet. So why this apprehension?
I'm very
Huh?
new to this
Now,
property.
just clarify one thing. When did you meet with that accident?
1998, your lordship.
Huh?
1998.
1998.
Yes, your lordship.
Okay,
During working
and you
hours.
were hospitalized till when?
I got this just few minutes back, your lordship, so I couldn't go through properly, your lordship.
And okay, you have done so much, so we'll give you an opportunity. We'll have this matter again on Tuesday. Prepare, and you will have to argue. Another thing, you will also have to satisfy this court where you were serving after your accident, more particularly after 2000. Where were you being engaged? These two things placed before this court, and then we will consider. Right? Let him prepare.
Yes.
Right? He has said so much.
Yes.
That's enough. On the prayer made on behalf. What's your name?
J. Raman, your lordship.
J. Raman.
Yes, your lordship.
J. Raman, learned counsel for the petitioner. List this matter again on 2 तारीख को कर दी. 2/4. Prepare.
Highly
Well.
obliged, your lordship.
But these two queries you will have to satisfy. Right? 98 onwards where you were, and after 2000 where you were. And you can do it. Just study a little bit more. Go.
Highly obliged, your lordship.
Yes, anything?
Okay. Lordship, the 1982 service rule is very clear, Lordship. We can, we have the option to go for a promotion or Lordship. And so far as 2015 rule, Lordship, that provision has been given by. Now it is 100% promotion.
Where is that?
2015. I have given the rule, Lordship.
15 rules. You have
15 rules.
15 rules. Just show me.
15 rules.
There was in between, there was a 2012 amendment.
That was an amendment.
You have that amendment copy with you?
I don't have, but
You have-
2015 I have.
Sorry.
Just check whether there is something there.
15, they have made it 100% promotion.
That's true.
And Lordship, I'll be relying on this Haryana Civil Secretary's case. It's an absolute domain of the executive. Even the court should not delve into all those things.
But no,
Even-
Mr. Chakraborty, we are only.
Even
on
if
one
there
point.
is a, it has,
No.
decision has to be taken by the
No.
executive law.
The position is already clarified by 2 decisions of this court upheld by the division bench. Wherein one I myself had appeared. Wherein it was said that if the diploma is and qualifications prescribed for that post, then you will have to attach that pay. Right?
But in this case, all those, the overseer
No, no,
post was March
I'm coming to it.
as per policy decision, Lordship.
Forget it. That is before. We are talking about the fifth CPC. Posts have not merged, the scales were merged. 5,000, 8,000, 5,500, 9,000, 6,500 something. These three scales were merged to one scale.
No, Lordship,
9,300.
merger was done in 2010.
10. So we are in 2006 basically in this issue. Okay, Mr. You give me that 2012 amendment.
Yes, I said, but one thing is Lordship, that electrician part which I have, Lordship will have at page 4 of their affidavit in opposition. They say they have given it to the electricians.
That show me.
Page 4. Para 6
Page 4 of the affidavit.
of their affidavit in opposition. Paragraph 6. The government of India by the letter number so and so 2009 merged the pay scale of overseer with the promotional post of PR, implementing the recommendation of 6 CPC. Subsequently, pay scale of charge mechanic, charge electrician. Also
Where?
Para 6, my lord.
Para 6.
4, Para 6.
Subsequently, pay scale of so and
Charge
so.
mechanic, charge electrician. Also updated being similar case like overseer in the technical branch. Then Lordship will come to page 5, Para 7. Non-diploma holders of BRO like charge mechanic, charge electrician. These all are coming in. But one thing I have seen, my lord, that also I will point out, the recruitment rules which are placed before Lordship, which I also see, it is page 88 and page 105. The many pages are missing. I tried to get the entire thing.
You give me the entire.
Now, the charge electrician, it has some posts for direct recruitment at that point of time. From what I have just gone through in my mobile, I could not take a printout because I received it just now. But even then, my lord, my argument would still remain that when it is by promotion, failing which by direct recruitment, the element of direct recruitment remains. That was always in the mind of the legislatures when they framed the recruitment rules, that it can be by direct recruitment, and if it is by direct recruitment, then this is the qualification, it has to be a diploma. By that logic,
We'll keep it for delivery of orders, but give me that within a day or two.
Yes.
By Monday, you can give it?
Yes, Monday.
List this matter again. A hearing.
Monday.
Hearing, I heard the party settling. List this matter again on 8/4/2024 for delivery of orders. You can give it to me. Only that much only.
That recruitment rules, the full recruitment rules I'll give, and the
12th amendment.
12th amendment was not regarding the charge mechanic.
Just give it. We'll go through it.
I'm obliged.
I have lost all those.
And I have given one judgment, my lord, of the Punjab and
You have given. But they are diploma holders there, basically.
Lordship, I'm handing over
the
the decision which I'm relying.
Obliged.
It file to move orders, delivery of orders or something. Yes. Yes, Mr. Mozumdar. What is this?
This is unlisted, my lord. I don't even have a copy.
Hmm?
The second copy, my lord. We have not been.
Second copy.
I don't have a copy. Absolutely.
Just see page 16, 18. Page 16 and 18.
Yes, madam.
In persons of block limited the following institutions are given temporary authorities in charge headmaster to disburse monthly salary. Ms. Amika is from 13/1 to further orders. In the interest of students to maintain PTR and improve quality education, Sri Ramchandra Saha science teacher transferred. Existing headmaster of Kuarmara is directed to hand over existing Kutumara is directed to hand over charges to Ramchandra Saha. Early orders of 7 done. Yes, madam. Seen. Seen, madam.
Page 18.
So, you are replacing one ad hoc by another.
It is, my lord, in my,
He is also a science teacher. He is not a headmaster.
in my humble submission, my lord, when we talk of replacing an ad hoc by an ad hoc, this is not an ad hoc, my lord. This is under 49C. If it is under 49C,
No,
it is
what I'm trying to
temporarily
tell you is that he was continuing until further order.
Yes. Yes.
Now,
So the moment,
once you have brought him here because of this rationalization thing,
yes, yes.
how can you?
If, my lord, that person is senior.
Senior, fine.
And
Go
and
for
he
direct
has-
recruitment.
And he
Go
has,
for regular
my
promotion.
lord, that, of course, that can be, my lord, otherwise, the senior person who is now in the school, in case of a 49C arrangement, it is not an ad hoc appointment. But this 49C is not an appointment. It is just holding a charge.
Yes, I was
If
also
it
holding
is
charge.
holding of a charge, the concept
You
of
get your instructions.
ad hoc appointment,
You get your instructions. Why this was required? What is his seniority? Everything you just check up. We'll pass for this. But Mr. S.C. Biswas, counsel appearing for the petitioner. Also heard Mr. R. Mujumdar, standing counsels, Department of School Education. So issue notice returnable 4 weeks. Mr. R. Mujumdar accepts notice on behalf of respondent number 1, 2. Also heard Mr. B. Dury, Junior Government Advocate of Port Valley. Mr. R. Mujumdar accepts notice on behalf of respondent number 1, 2, 4, and 5. Mr. B. Dury accepts notice on behalf of respondent number 3. Also, the petitioner who projects himself to be the founder teacher of Kukurmara Girls ME School. The services of the petitioner, who projects himself to be the founder teacher of Kukurmara Girls ME School, was provincialized under the provisions of the Act of 2011, Pura Liksegan, Assam Senior Venture Education Act of under the provisions of so and so with effect from Act of 2011 with effect from 1/1/2013. Also, the petitioner was white an order dated 7/2/23 issued by the District Elementary Education Officer, South Salmara Mankachar, by the Jurisdictional District Elementary Education Officer, allowed to act as the in-charge headmaster of the school in addition to his normal duties with effect from 31/1/23. The petitioner accordingly contends that he is continuing in his services as the in-charge headmaster of the school. Also, while an order dated 14/3/2024, the Jurisdictional District Elementary Education Officer has posted posted the respondent number 6 to the school of the petitioner. Transferred and posted the respondent number 6 to the school of the petitioner, and on such posting, he was allowed to function as the in-charge headmaster of the school wherein the petitioner is presently functioning. Full stop. The transfer and posting as reflected from the order date, transfer and posting of the respondent number 5 as reflected from the order dated 14/3/2024 was so necessitated to maintain the pupil-teacher ratio bracket PTR, and also improve the quality of education. Also, it is the submission of the learned counsel for the petitioner that the said order has the effect of replacing one ad hoc by another. Full stop. Mr. R. Mujumdar on the next date fixed shall receive his instruction as to as to the service details of the respondent number 6. service particulars of the respondent number 6. Full stop. The above particulars would be required to examine as to whether the said particulars of so and so. Mr. Majumdar shall also apprise this court as to the manner in which the respondent number 6 was so selected for the transfer and posting to the school wherein the petitioner was so posted. Also, till the next returnable date, the order dated 14/3/2024 shall
Annexure 3, my lord.
Annexure 3 bracketed Annexure 3 shall remain suspended.
Today is 28th, 14/3. The charge handing over, taking over could have well been done. I do not know.
Oh, yes, yes.
14/3, my lord.
Full stop. Full stop. Till the returnable date, comma. In the event the respondent number 6 has not taken over charge of the.
Not yet, I have not yet given the charge. I
You
have
need
mentioned-
not. He
Anyway,
should take over.
Yes.
You need not.
Yes, yes, you can take over.
He can take over. He has not taken over charge of the post of headmaster, Kukurmara Girls ME School, comma. And is not functioning in such capacity, comma. The impugned order dated 14/3/2024 shall not be given effect. Because bills will have to be signed
Yes, yes.
today.
Yes.
So if we stop him, it's not, if he's functioning, you are here in Guwahati now. You are in Guwahati today.
Yes, yes, ma'am.
Signing the affidavit.
I'll collect it today, it's arrived by Friday now.
Yes. Yes, Mr. Sharma. Anything? Oh, no, elementary. Mr. Pukon was here. Give him a copy. We'll take it up after some time. Give him a copy. Give Mr. Majumdar a copy.
I'll take the second copy.
We'll take it up after some time.
Second copy.
Second copy to DD.
After some time.
Let him go through it once. Where is Mr. Abedin? Huh? Huh?
All the matter at 3 o'clock and
Okay, he's doing some matter.
on prayer.
So now what to do with this? Hmm? 3 o'clock. Here, okay, 3 o'clock. At 3 o'clock. Mr. Das, any information? Can something be done?
No, Lordship. We said procedure is there, Lordship. We have one meeting should be held by the CS Lordship, Chief Secretary, then it should go to the Lordship Election Commission. Long procedure, even Lordship. In coming 1st of April, Lordship, our principal secretary, director, as well as secretary, all are coming to the court.
Why?
Yes, because of the order was passed by the Honorable Chief Justice for compliance of the Honorable Court's order, Lordship.
Now they can't.
They cannot, Lordship, even Election Commission, they have sitting and proposal is also given, Lordship, that cannot. That is the reason. In one of the principals appointment.
Honorable efforts for the held that we make it clear that the election code of conduct will not be treated as an impediment to comply with judgment of this court.
Fine,
And
but,
there is a procedure.
there is a procedure.
Procedure have to follow, Lordship.
They has to follow a procedure. They have not done it, we'll hold them for contempt.
Even
We'll-
Lordship,
we'll-
paragraph 9 and 10, my lord's order is very specific.
After some time, that you.
No, we'll issue a notice. Mr. Abedin otherwise is also too much agitated today.
At least for 1 day, my lord. For his promotion.
Even Lordship.
We would also love it, but we have a procedure. Now we are going to haul up them for contempt. Heard Mr. J. Abedin, learned counsel for the petitioner. Also heard Mr. You're not appearing?
Lordship. If Lordship, that way I can appeal, Lordship.
Also heard Mr. Analay.
No.
Issue notice, returnable 3 weeks. Petitioner to take steps for service of notice upon the sole respondent. by way of registered post with AD. Full stop. List this matter again. After, again on 3 weeks again, last week again, 28. Thursday, 3, 2, 3. On 22/4/2024, full stop. It is provided that the sole respondent is at liberty to comply with the directions passed by this court, while the order dated
16.
16/2/2024 in WPC number 531/2024. Right?
I also communicated, even few minutes ago, I also lordship talked to her. Even CS also whole meeting regarding principal's case, that was also negated by the election commission.
Okay, fine.
Yes.
Can't help it.
If possible, my.
We have protected your interests, so there is no problem.
Apology.
Can't help it. Everything you don't get sometimes.
That is right.
ತುಂಬಾ appear কৰিছিল নেকি আগতে না? আহিছিল।
Senior is on car.
Kandit, heard, what is your name?
Yes, Hussein.
Yes, Hussein. You have something to say? The present writ petition has been instituted by the petitioner, assailing the selection and appointment made against the post of LDA bracketed grade P in the office of the establishment of the Foreigners Tribunal bracketed Roman 3 Sonitpur Testbook. So they said recruitment also. Also, the petition, the writ petition has contended that an advertisement was issued on 13/12/2011. Nanda, just if something facts are there, just correct it for me, okay? 13/12/2011, inter alia, inviting applications amongst others for the post of LDA in the for one post of LDA in the establishment of the Foreigners Tribunal bracketed Roman 3 Sonitpur Testbook. The petitioner, being eligible, had submitted his application along with that of submitted his application in the matter. Also, likewise, the respondent number 7 also had submitted his application. Also, it is contended by the petitioner that while he had secured 57 marks in the written examination, the respondent number 7 had secured 56 marks. But however, on conclusion of the viva voce segment of the selection process, the respondent number 7, who had by then scored an aggregate of 70.4, was selected for the post in as much as the petitioner could only score 68.2 on conclusion of the selection process. It is the contention of the petitioner that on perusal on receipt of the answer scripts of both the petitioner and the private respondent number 7, and on a perusal thereof, it was found that the answers as given by the respondent number 7 was wrong, but he was awarded marks for such wrong answer, whereas the marks scored by the petitioner whereas the answer given by the petitioner, although being correct, was denied the marks thereof. Full stop. This court, full stop. Accordingly, it is submitted that it is further submitted that where has he brought the mother thing? His mother is working.
Lordship, one marks is given, more marks is given to the respondent number 7. And if you see the page number 29, it is, this question answer is wrong, but they have given the 1 numbers.
Then,
That's
next, next, what is the problem? Come out, start, argue. I want you to do that, argue.
1 marks is more. But,
Okay, okay. Stones are hard to be broken.
broken.
That is one,
But
okay,
this
then
is,
next,
This is wrong.
then
So 1 marks will be deducted from.
deducted, okay, we deduct
respondent
1
number
mark.
7.
Then next.
Then he will get 56 to 55. Then
Still, he will be above you. 1 mark. 1 more mark has to go. Show me. Next one. Next one. Which one?
My lordship, respondent, when interview was taken by the respondent authorities, then the petitioner have taken only 11.2 marks. And on the other hand, respondent number 7 get 14.4 marks.
Right.
On the basis of they have get only 0.2.
This is what is required. No. This is how you prepare. You argue. Now you have read so much. You have understood the case.
Yes.
We'll have it on Tuesday. Prepare further. If you come for an adjournment before me, I'm not giving it. Do the case, make me satisfied, take an adjournment. Tuesday. But you will have to argue. I'll not hear anybody else.
Okay, my lord.
No, we'll give him a chance. List this matter on the prayer of Mr.
Yes, Hussain.
S. Hussain, Learned Counsel for the petition. List this matter again on 2/4/2024 for further hearing.
God bless.
And next time, when you come, don't come for an adjournment. Prepare the matter, come before me. If you find any problem, I'll help you.
Okay, my lord.
If you come before me with all this other thing, yes.
Lordship, the last occasion you had said regarding that page 66.
What to do?
Lordship, well,
Any private respondent here?
My lord, she was served, not. She was noticed or served, but she is not a hearing.
Notice was served.
Served.
Her services have also not been provincialized.
She will not be provincial.
No, not provincialized.
Not provincial. Because her name is not in Dice data after 2012.
She is respondent number 6.
6.
Heard, Mr. Khandaka. M.R. Khandaka, Learned Counsel for the petitioner. Also heard Mr. A. Fukon, Learned Standing Counsel, Elementary Education Department, appearing for the respondents number 1,
all the response. Oh,
2, no,
5
4,
and 5.
5. Also heard Mr. B. Dury, Learned Government Advocate, appearing for the respondent number 3. None has entered appearance for the respondent number 6. The petitioner has, by way of instituting the present proceedings, presented a challenge to an order dated 25/4/2023, by which her claim for provincialization of her services as a language teacher, in Silghari ME School was rejected on the ground that the name of the petitioner did not find mentioned in the recommendations made by the District Scrutiny Committee.
District already.
A state level scrutiny committee. Full stop. The Learned Counsel for the petitioner submits that in pursuance to the directions passed by this court wide order dated 31/3/2021 in WPC number 2398/2021, the Director of Elementary Education Assam had considered the case of the petitioner and wide an order dated 7/1/2022, the claim of the petitioner came to be rejected on the ground that her name was not so recommended by the state level committee, as well as by the joint committee so constituted by the government for provincialization of our services. Also, the petitioner thereafter instituted WPC number 2893 of 2022, presenting a challenge to the said order dated 7/1/2022. This court, while order dated 6/5/2022, proceeded to give a final consideration of in the writ petition being WPC number 2893 of 2022 and with the following with the following observations. Final consideration to the said writ petition 6522, final consideration to the said writ petition, remanding the matter back to the final consideration to writ petition number so and so by interfering with the order dated 7/1/2022 and directing the Director of Elementary Education to determine as to who would be entitled to provincialize and accordingly pass a reasoned order thereon. Also, this court, while proceeding to pass the above direction, had recorded the following conclusions in the order dated 6/5/2022. A to A. Page 60, 63, 64. Pura video. 63, 64. Also, in pursuance to the directions as passed by this court, widely said order dated 6/5/2022, the Director of Elementary Education Assam had issued the order dated 25/4/2023. Also, on a perusal of the order dated 25/4/2023, it is reflected that the same is just a replication of the contentions as contained in the order dated 7/1/2022, which has since been interfered by this court. Also, it is also revealed that while passing the order dated 25/4/2023, the Director of Elementary Education Assam has not considered the observations as made by this court while the order dated 6/5/2022 and had reiterated what was earlier said, what was earlier noticed while the order dated 7/1/2022. Also, it is seen that the name of the petitioner was initially recommended by the Jurisdictional District Scrutiny Committee for provincialization of her services as a language teacher. Also, thereafter, the matter was placed before the State Level Scrutiny Committee, and the State Level Scrutiny Committee, on examination of the matter, dropped the name of the petitioner from the list of persons recommended by it to be eligible for provincialization of their services. Also, the name of the petitioner was so dropped on the ground that she was an additional teacher. The name of the of the respond number, six. Six was also not recommended in as much as her name was not found in the dice code up to 2011-12. As the name of the petitioner was not recommended by the said committees, the director of second elementary education, Assam, proceeded to provincialize services of two teachers, one against the post of science, one against the post of science subject, and the other against the post of subject of social studies. Full stop. It is contended the bar that the post of language teacher as required to be filled up in terms of the provisions of 311 of the Act of 2017 is still lying vacant in the school. Also, in view of the above, the present petition stands disposed of, requiring the Director, Elementary Education Assam, to place the case of the petitioner again before the state level scrutiny committee. The state level scrutiny committee, in exercise of its powers under the provisions of section 1311 of the Act of
17.
1311 of the Act of 2017, and after by exercising its by the state level scrutiny committee, by exercising its power under section 1311 of the Act of 2017, shall, after causing a physical verification of the institution and on examination of the contemporaneous records as maintained in the school, and after ascertaining as to whether the petitioner was in continuous service in the school as mandated under the provisions of, for the period as mandated under the provisions of the Act of 2007, shall make its recommendations with regard to the provincialization of the services of the petitioner as a language teacher against the post of language teacher presently lying vacant in the school in question. Full stop. The Director of Secondary Education Assam, on receipt of elementary education Assam, on receipt of such recommendations from the state level scrutiny committee, shall proceed with the matter in accordance with the recommendations so made. Full stop. In the event the case of the petitioner is recommended by the state level scrutiny committee for provincialization of our services, the director shall pass the requisite consequential orders thereon after receiving necessary approval from the government in this connection. Also, in the event the case of the petitioner is not considered, is not recommended for provincialization by the state level scrutiny committee, the Director Elementary Education shall issue a speaking order incorporating therein the reason for such rejection of the case of the petitioner for provincialization of our services and communicate the same to the petitioner. Also, the above exercise shall be initiated and concluded by the Director of Elementary Education Assam within a period of 3 months from the date of receipt of a certified copy of this order. Also, the petition is hereby required to furnish a copy of certified copy of this order before the Director of Elementary Education Assam for taking the matter forward. With the above observations and directions, the petition stands disposed of.
My lord, order 25th April 23.
We'll correct it. I'll correct it.
It is it.
Oh, it was full stop. In view of the, it was just a good day. My conclusions are finally, in view of the above, the order dated
25 4/2023.
25/4/2022.
23, my lord.
it's 22 here.
Yes, my lord. 2 dates, but page 66. Page 66.
23. 25/4/2023. Stands set aside. I'm out. Now we should make it. What did you? Itu. Tapi Arun Trivasani. Yes. With that beautiful smile sitting there, it looks nice.
Yes, deputy obliged.
He is the culprit.
No, he made sure that it doesn't happen.
No. I think you must have a discussion outside.
Since morning, Lordship.
I think you better wait here only.
No, he won the battle, I'll leave now.
Since morning.
You will win the war.
No, my lord, it's.
You will win the war. He has just won the battle. The war is yours.
Since morning, Lordship.
Sometimes tastes are not there. I don't think I'll appear for this contempt again.
Why?
The test is over. This man wanted that one day. Now he'll get it, my lord. Hopefully, he will get that order with your lordship's earlier order in the writ.
We contemplated that. That's why he passed that order.
Yes.
Anyway, can't help it.
Sometimes it happens. Deeply aware.